Yes. What's the urgency? Tomorrow. Arrest warrant. Tomorrow. Tomorrow arrest warrant. Tomorrow wait, 2:30. 2:30 today. Very well. 2:30 today. Yes. Tomorrow. Let us. No. Disposed, nothing else. Yes, next. No. No. Tomorrow. Withdrawal. 2:30, sir. 2:30 withdrawal. Monday. Yes, very good. Yes, ma'am. Yes. Will. Yes. Culture. Yes.
Adjournment. Serial number 30 to 39. Page number 6.
30? After vacation. Wait then. For extension, wait. For extension, you wait. Let us wait. Yes.
Serial number 30 to 39. 40 to 44. 40 to 44, 45 to 51,
47. You are for? At the request made by the Nana Council for the petition. List after summer vacation. Interim order granted earlier, extended till next date.
serial number 52 to 58, serial number 52 to 58, serial number 62 to 64,
Yes.
serial number 1.
I am appearing for petitioner counsel, my lord. Kindly grant a week's time, my lord.
No, what is the matter now? What is the
One
matter?
month.
What is the matter? Yes, what is the matter?
Matter for impleading application, my lord. In
Who has filed the impleading application?
plaintiff filed the impleading application, my lord. That is came to be allowed, my lord.
Came to be allowed. Yes. What is the
Yes, my lord.
finding recorded by the court? It's a suit for partition.
Yes, my lord.
Yes. That right to the court has allowed the impleading applicant. Yes, sir.
My senior will argue the matter, my lord.
No, nothing else. Nothing else. Impleading applicant say that the suit properties belong to her father, and he had also executed GPA in favor of the first defendant. Proposed defendant is a paternal uncle, and she has challenged the petition. Not trial court is justified. Take it.
My lord,
This petition is.
my lord,
This
kindly
petition
grant
is
the
filed
time,
by
my
the
lord.
defendant. Yes.
Senior will argue the matter, my
Yes.
lord.
No, let's let this petition is filed by the
My lord, I
defendants.
request you, my lord, kindly pass over, my lord. My senior will argue the matter, my lord.
Okay. Pass over I can do.
2:30, my lord.
No. Let us we will see. After preliminary, it will be taken up.
Serial number 2, the case criminal.
My lord, I am appearing for the petitioner, my lord. My lord,
Yes.
I have challenged the order passed by the trial court, thereby rejected my impleading application for the trial court,
Yes.
my lord. So, my lord,
Yes,
here is the case, my lord. I have purchased the property from the defendant, respondent number 1 to 4 during the year
Yes, sir.
2002, my lord. You will ask me kindly turn to page number annexure A, page number 19, my lord.
Correct, sir.
I purchased the property which was carved out of the suit schedule property from the respondent
Yes, sir.
number 1 to 4, my lord. Then, my lord, the plaintiff here in the first respondent here in filed a suit for partition, claiming that it is the ancestor property and she is also having right over the property.
But
My lord,
you were right. But your right will be considered only in the FDP proceedings.
no, you will also kindly appreciate. Then how I will come to know that, my lord, when is the suit, what happened to
No.
the
First
suit?
of all, the shares of the parties have to be determined.
No,
This is a
sir.
suit for partition.
No,
Unless the rights of the parties are.
No. Then I should be notified, no, my lord, because I am the bona fide purchaser. Along with me, others
Maybe
also.
true.
No. You will also
Right,
kindly
bona
say
fide,
whatever the finding given by the trial court is not correct, my lord. The
yes,
point
well,
is that the trial court stated that I filed the suit. They filed the suit during 2018,
yes,
and I filed purchased the property during 2002.
yes,
And nothing prevented me to implead unless and until I get the notice from the court or
yes,
I impleaded. How I
yes,
can come to know, my lord?
yes.
My lord, your lordship
No,
is
yes. You are no objection to allow. Yes. No, it's not that. Only it's for order 1 route 10-2 you say. Let it be allowed. They will be also heard in the matter as such.
yes,
Slowly. This petition is filed by the proposed defendant. No objection like under 226, madam. These are all CRP matters, like CRP. Earlier 115 matters, revision matters. This writ petition is filed by the proposed defendant in OS number 8090 of 2008 on the file of the 38 additional city civil and session judge Bengaluru city, challenging the order dated 27/3/2019, dismissing the application filed by the impleading applicants. Relevant facts for the adjudication of this writ petition are that the plaintiffs have filed suit seeking partition and separate possession in respect of the suit schedule property, and the defendants entered appearance and filed detailed written statement denying the averments in the plaint. In the meanwhile, the petitioner / proposed defendant filed application in IA number 15 to 18.
No, I filed IA number only one IA, my lord.
Only IA number 15.
Yes.
Only IA number 15.
Because along with others, I also filed the impleading application with the grammar order has been passed, my lord.
IA number 15 to 18, yes, filed under 1 Rule 10 Clause 2 of CPC, and seeks to implead as the defendants in the suit. The said application came to be allowed by the trial court by impugned order dated 27/3/2019.
Rejected, sorry.
It came to be rejected by impugned order dated 27/3/2019. Feeling aggrieved by the same, the proposed defendants preferred this writ petition. I heard Shri K.S. Bhimaya, Lana counsel appearing for the petitioner, and so Lana counsel appearing for the respondent. Lana counsel appearing for the petitioner contended that, the proposed defendant is the owner of the site bearing number 94, which is carved out of the survey number 77/1 of Kottanur village, Bangalore South Taluk, and the said property is also one of the scheduled properties in the suit, and therefore he has to be heard in the matter. Per contra, Mr. So-and-so and a counsel appearing for the respondent sought to justify the impugned orders. Perusal of the writ petition would indicate that it is an undisputed fact that the suit is filed seeking partition and separate possession in respect of the scheduled property, and perusal of the affidavit accompanying the application by the proposed defendant would indicate that one of the properties in the suit scheduled properties is belonging to the proposed defendant / petitioner herein, as he has purchased through registered sale deed in the year 2002 and 2006 respectively. And in that way of the matter, in order to effectively adjudicate the matter on merits, the proposed defendant / petitioner herein is required to be heard in the matter. Accordingly, the petition is allowed. Order dated 27/3/2019 in OS number 8090 of 2088 is set aside. The proposed defendants / petitioners to be arraigned as the defendants in the suit. Accordingly, the petition is disposed of. Yes. Yes. R1 and R2. Notice may be told. Yes, sir. Emergent notice. R1 is told. Yes. Then a counsel appearing for a petition file memo dispensing notice insofar as the respondent number 2 is concerned. Same is accepted at the risk of the petitioner. Issue emergent notice to respondent number 1. Yes. Yes, sir. Very well, sir. Within 2 weeks. Sir. Again, you have to take steps. Yes. 2 weeks time to take steps insofar as respondent number 1 is concerned. Non-compliance. 2 weeks time is correct. Yes, ready? Pass over, madam. Very good. Pass over. Await service of notice of R1 to R3. That the petitioner has to say. No, petitioner has to say actually. If you file a memo, I can dismiss with the notice. File a memo. Then a counsel, green sheet code. Then a counsel appearing for the petitioner submitted that the notice to R1 and R3 be dispensed with and the memo is accepted at the risk of the petitioner. Full stop. Notice to R1 and R3 is dispensed with. Yes, sir.
And rest of the respondents, except 4, they are also the corporate bodies. They are registered say one is grant house.
If you are ready, I will take it up.
Those are also not.
Let us will take it up. No. If you are ready, I will take it up. Ready. What is the matter now? Order 6 through 17. Amendment. You are for this, sir? You are for... before a trial court, you are the plaintiff. Yes. What is suit for?
Suit for we have filed for what happened is
Suit for?
striking of the entries and consequential injunction.
Yes. Suit for. At what time, at what stage that you filed an application? At the stage of plaintiff evidence?
Framing of the issues, matter was listed for evidence.
Yes, on what ground?
Commencement of evidence.
Yes, sir. What is the amendment you sought? Just go to application.
Section B.
Annexure D. Annexure D, yes.
This is with respect to granting of means for illegal occupation of
Yes, plaintiff to add the following paras 18D to add para D1 to hand over the vacant physical possessions by removing the put up by the defendant number 2 to the plaintiff. Yes, sir.
Another is annexure D1 for means of.
You filed 2 applications,
Two applications.
mean profits.
Another
Suit
is
for?
Suit for striking of the entries which was done during the pendency of the trial, original suit.
We go to what is it? Prayer in the plaintiff.
Main prayer matter.
Directing the respondent defendant number 5 to strike a score of the illegal entries. So bearing number 7. What is the entry in the register?
They have illegally entered safely during the pendency of the suit. That is the original defendant in the OS number 25, the mother suit. during the pendency of the suit, they entered into a transaction and statement was executed.
Yes.
So we sought, because miscellaneous comes, we have sought for striking of the entries.
Hmm.
And consequentially, the injunction also we sought. That is why the kata was transferred based on the.
Yes, sir. Yes.
That also we have sought for striking.
Yes, sir. I think you are aware about all these things at the time of filing of the suit.
We filed an injunction application. It was rejected, saying that you were sought for.
You are aware about the proposed amendment even at the time of the filing of the
This
suit.
was we were not aware. Subsequently, we came to know there is a safety statement.
When was this was that you came to know in the earlier itself.
No, because we have filed in.
You go to proposed amendment. What you said. You are well aware about the same at the time of the filing of the suit.
We filed an injunction application.
Yes, sir. Sir, you go to Annexure D. You hand over the vacant physical possession of the switch over by removing the semi-structure put up by the defendant number 4. That the defendant number 4 has put up the construction was well aware about you even at the time of the filing of the suit.
Just we started.
Yes, that you are aware even at the time of the filing of the suit.
Filing of the suit, they come.
You are aware, but why you are not at that at the time of after the 4 years now you are after 4 years you are. What is the due diligence then? That's why the court has rejected it. Even at the time of filing of the suit, you are well aware that the defendant number 4 has put up the construction.
No, we have not. We have not only for striking out. But tomorrow they should not claim
No, sir.
equity. For that purpose, safeguard we have sought for additional.
What about the due diligence? Though you are well aware about the same facts, even at the time of filing of the suit in 2016, you sought for that prayer at the time of filing of the suit.
Yes, sir.
Then,
At the time of evidence, we realize that this
Yes, sir.
structure has to be, because it is not completely.
that realization is not correct. That realization is not correct. When the matter is posted for evidence of the defendant.
Because it was a semi-section, we also can remove it.
Yes, yes.
But safer side tomorrow they should not claim any.
Not a case for interference. Not a case for interference.
So in that condition, that
Yes, sir.
it is very clear that in the 2004 itself,
To
2004,
2004.
there is second appeal is coming because these are
Second appeal.
second appeal.
With respect to this, with respect to the same scheduled property,
Same to my vendor's property.
where is that?
That is in additional document.
Additional document.
Number 4. It's not number 4. It's not document.
Just a minute. 1 minute.
Page number 29.
29.
Yes. It is the order of the second appeal.
One.
Number 4.
That's order dated 17 November 2015 RSA number so and so. Yes.
Guide is the present petitioner officer. Present petitioner.
Yeah, Ram Prasad. He is the
Yes.
appellant number 1.
Yes.
1.
Appellant number 1. He is seeking the leave of this.
So,
Seeking the leave of this. Respondent number 4.
the subject matter is 1 and 3. Yes.
But the original respondent number 1 was the purchase the property of respondent number 4
From-
through court action. His property is different, my property is different. Therefore, present seeking the amendment of the line is not there is no difference.
No, it will even change the nature of, even it will go against the order, judgment and decree passed by this court in RSA also. Actually. Third.
My own position.
Yes, sir.
This report, there is a resolution was filed by them only. There, this one report has granted the leave. They can appoint a commissioner to find out the revenue is over.
That's a different. Only my concern is what is the application before me. That's all. I don't want to consider about other applications.
There are two judgments.
Yes.
Although Supreme Court also says,
Um,
even there is a delay, if it is not changing the nature of the suit,
yes.
it can be allowed.
But in this case, already RSA order 2 RSA is in this court has already in judgment and decree given a finding.
No, that RSA subsequently only suit was filed by law.
Yes, that's
Based on
why.
that only suit was
That's why it will go in the event if the said application is allowed. It will go against the judgment and decree of this court in RSA.
That after RSA was allowed, then only the original suit was filed.
Yes, sir.
And so original suit decreed.
Yes, sir.
And this suit is subsequent to the decree only.
Yes.
Based on the decree.
You cannot raise this plea even after a considerable period of this is RSAs of 2004, and subsequently in 2016 this suit is filed.
No, suit was, my lord, before filing of the suit, the statute was 19.
Yes.
My prayer is with respect to removing the structure which they started just filing before
Yes.
filing of the suit.
Even otherwise, you are well aware about the same even after 2016 also. All interested stop. Totally. This writ petition is filed by, please don't. This writ petition is filed by the plaintiff in OS number 245 of 2016. Yes, sir.
The Honorable Trial Court dismissed my application only on the ground that just before the commencement of, after commencement of trial only they have filed application. In this regard, the Honorable Supreme Court and Honorable High Court also says, trial is after commencement of the evidence. It is not before that.
Yes.
Even the matter is listed for evidence, it's also not.
Yes,
So on
correct.
that
Like
aspect,
that you can make an application at any stage, but
Yes,
you
sir.
give explanation for why you are not raised at the time of the filing of the suit. That's very important.
Due diligence, I am relying on this one, my lord.
Yes, yes.
Even after 3 years,
Ah.
Honorable Supreme Court said it is not an inordinate delay.
I know, I am aware. Probably it is with explanation, proper explanation. Here at the time of the filing of the suit, you are well aware.
It is up to lintel only, my lord. It is not fully constructed.
It will be constructed now. Let's enlighten.
No, my lord.
No, not a case for interference.
Yes.
Yes.
Justice,
Told me,
has given an order.
Huh? OS number 245 of 2016 on the file of the first additional civil judge and JMSC Chikkaballapura, challenging the order dated 16/3/2020, rejecting the application filed by the plaintiffs under Order 6, Rule 17 of CPC. Plaintiffs have filed a suit against the defendant, seeking relief of directing the defendant number 5 to strike off or score off the legal entries or the registrations at Annexure D bearing registration D dated 7/7/2006 and consequential relief of permanent injunction restraining the defendants from interfering with the suit schedule property. The said suit is resisted by the defendants by filing written statement. In the meanwhile, the plaintiff has filed an application under Order 6, Rule 17 of CPC to amend the plaint and also to direct the defendant number 4 to deposit rupees 16,000 per month as mean profits from the date of the suit till the disposal of the suit. The said application was resisted by the defendant number 4. The trial court, after considering the material and record, by impugned order dated 16/3/2020, rejected the application and feeling aggrieved by the same, plaintiff has preferred this writ petition. I heard Sri Balaji Raghunathan and a counsel appearing for the petitioner and Mr. So-and-so and a counsel appearing for the respondent. Sri Balaji Raghunathan and a counsel appearing for the petitioner contended that the finding recorded by the trial court, particularly at para 20 of the impugned order, that the said application has been filed by the plaintiff without explanation with regard to the due diligence is incorrect and same is required to be interfered in this writ petition. He further contended that it is open for the parties to file application seeking amendment of the pleadings at any stage of the proceedings, and therefore, the finding recorded by the trial court requires to be interfered in this petition. Per contra, Mr. So and so and a counsel appearing for the respondent contended that the application filed by the plaintiff is after 4 years from the date of the filing of the suit, and in the event if the application is allowed, same would change the nature of the suit, and therefore the finding recorded by the trial court is just and proper and same cannot be interfered in this petition. He also made available the judgment and decree of this court in RSA number 1176 of 2004 connected with RSA number 1177 of 2004 dated 17th November 2005 and submitted that the plaintiff in the present suit is the legal representatives of the deceased appellant in the aforementioned regular second appeal, and the said appeal came to be dismissed with regard to the same scheduled property, and therefore he sought for dismissal of the writ petition. In the light of the submission made by the Lana counsel appearing for the parties, I have carefully considered the finding recorded by the trial court as well as the proposed amendment sought by the plaintiff. Perusal of the finding, perusal of the writ papers would indicate that the plaintiff was sought for striking off the entries made in the registration certificate registered deed dated 7/7/2006 produced at Annexure D in the suit, and the proposed amendment is sought with regard to seeking the mean profits, as well as to add paragraph 18D to hand over the vacant physical possession of the suit property by removing the semi-structure put up by the defendant number 4. Looking into the affidavit accompanying the application, in the application filed under Order 6 Rule 17 of CPC, produced at Annexure D, it is undisputed fact the suit is filed in the year 2016, and the application seeking amendment is filed at the belated stage at the time of the evidence of the defendant. At the time of plaintiff and the type of plaintiff,
It is not a use.
and perusal of the writ petition would indicate that the defendant number 4 had started putting up construction over the suit property, and the same is the subject matter in the earlier suit in OS number 26 of 2005.
No, my lord, it is not the subject matter. That defendant is different.
Yes,
That
but,
is
but
different
subject
from one,
but subject matter.
No, that is only.
Parties may be different.
Intention and declaration, my lord. It is
Very
not,
good. And
doing
therefore,
the substance.
I must review that the trial court is justified in rejecting the application filed by the plaintiff, as the plaintiff has not proved the due diligence as employed in Order 6 Rule 17 of CPC for accepting the application filed under Order 6 Rule 17 of CPC. And in that matter, taking into consideration the fact that this court in the aforementioned regular second appeal dismissed the appeal preferred by the plaintiff, and in that view of the matter, I do not find any material illegality in the order passed by the trial court. Accordingly, the petition is dismissed as devoid of merits.
Regarding mean profit, my lord.
Dispose the suit as per as in.
No, sir. Matters will say. I don't know how many matters are there before the trial court.
There is no such, my lord.
As per as in.
No, I know, I don't want to.
As per as in.
I don't want to direct.
My humble directed them to seek for appointment of commission. They have not done it. That this restriction also.
Sir, this is only in for Order 6 Rule 17. This is only Order 6 Rule 17.
Regarding mean profit, my lord, that is not.
That's only is challenge Order 6 Rule 17. Next matter.
Public.
Serial number 6.
2 weeks time is granted to comply.
Serial number 7.
Same. 2 weeks time is granted to comply with the office
Serial
objections.
number 8. Repeat Surana. 2 weeks. 2 weeks.
Yes.
Serial number 8. Repeat Surana.
1 week. 2 weeks time is granted to take steps insofar as the unserved respondents.
Serial number 9. Arun Ponnappa.
2 weeks time.
Yeah, can you see? Page, you that review order.
Yes.
First, can you turn to page 225?
Yes, sir.
Page 225, that's a mistake. It's a mistake done by the court staff, not the court.
Page, sir?
Page 225.
225.
225.
1 minute.
It is a typographical error by the court staff, not the.
What is it?
First, can is the last one, order and below. Only content in charge of the court number 39 is there.
Huh.
Actually, it should have been 31. Vote on the 13 is vote on the 14.
That is only.
X1, Roman 10 has been added.
That is the only thing, or any other?
That's all. That's the only.
Anyway, sorry. Except in the submission made by the Lana Council appearing for the petitioner, the office objections is overruled. Yes. So Monday to Monday. This matter on Monday. If the office objection, if any, are complied with.
That's only one way.
If any. Yes.
Serial number 10.
Steps to be.
2 to 4 and contesting participants are only third.
Steps to be taken in respect deceased are 5 days. 2 weeks time. 2 weeks time is granted to take steps insofar as deceased R5 is concerned.
Process.
2 weeks to take process insofar as unserved respondents are concerned. Interim order granted earlier extended till next date of year. Yes.
Serial number 11.
Compliance of the office objection.
We have complied with it.
Then it will be taken up. On any other day. Oh, not 2 weeks. Dhananjay Kumar, 11. 2 weeks time is granted to comply with the office objections.
Serial number 12. Swati also.
Yes, office objection.
Complied with.
Then it will be complied. Tuesday, very well. Then a council appearing for the petitioner seeks 2 days time to comply with the office objections. If the office objections are complied with, list on Tuesday. Yes.
Serial number 30.
And when that's already compared without getting the correct, they were given a score for correct. Yesterday the matter was
Then a counsel applying for the petition is permitted to comply with the office objection within 1 week, failing which the fourth time, madam. This is fourth time.
1 week we did not found the time.
2 weeks. 2 weeks. How many days you want?
Monday.
By the time you can comply. Then a counsel applying. Then a counsel Monday, madam. Monday we have some. Tuesday, no, next Wednesday. Tuesday also some other matter.
13.
Yes, if the office objections are complied with, list on Wednesday. Yes, sir.
Serial number 14.
2 weeks time is granted to comply with the office objection. Yes. You comply with 2 weeks. 2 weeks time is granted. No, you comply with 2 weeks. 2 weeks time is granted to 1 week time is granted to comply with the office objection. If the office objections are complied with, list on 18th. Yes.
Serial number 50.
Non-compliant. Why? You served? You served copy? Yeah, you served it. Yes. Then a counsel applying for the petition submitted that he served the copy of the writ petition to the other side and same is accepted. And in that way of the matter, office objection is overruled. Yes, sir. If you are ready, I will take it. You know? Any other objections? Some other objections are there. No other alternative. No, you have to add para so and so. 1 week's time is granted to comply with the office objections. Yes.
Serial number 60.
Await service of notice.
Substituted service.
You file it in the register. File it in the register. Await. Very well. Await, sir. You are appearing for me?
Respondent number 1, 2, 3, 28, 45, 51, 55, and 55.
Just a minute. You give the list. Just a minute. Give the list. Because there are the 61. Await service of notice insofar as the unserved respondent number 1 to R1 to R61, Madam so and so submitted that she has been instructed to appear on behalf of the respondent number so and so. Interim order granted earlier extended till next date of hearing. Next date of hearing, interim order is extended.
Serial number 70.
Same. Take steps insofar as respondent number 2 is concerned.
I appear for respondent numbers 2 to 5 hours. I'll undertake the 5 hours.
You undertake. Your good name, please. 1 minute. Your good name, please. So and so submitted that he has been instructed to appear on behalf of the respondent number 2 to 5. Registry is directed to print the name of Mr. So and so in the cause list. Is this matter after vacation? Yes, list after vacation. Interim order granted earlier, extended till next date of hearing. Yes. You are appearing for yes, very. 2 weeks time is to comply with the office objections. 2 weeks time is granted to comply with the office objections. Sir, you are appearing for?
I am appearing for the petition in serial number 18.
18. Yes, sir. Comply with the office objection is there.
The matter is posted today for this reason, my lords. Your lordships may recollect your lordships' memory. The office objections is regarding the application which has been filed seeking
18.
dispensation. Your lordships were to dispense, then the office objections would not remain. But the reason why we have moved this matter is this. The petitioner is a national.
What is the urgency, sir? Or what is the urgency actually?
Today the matter is listed for orders regarding the extension of time which we had sought for before the trial court. If in the event the delivery warrant is issued, then it's a nationalized bank. We are holding about 4,000 accounts and there are about 300 lockers, which are provided, and it's a cash
Yes,
facility.
yes.
Is not,
Yes,
they're
sir.
only
Yes, sir.
saying
Yes, sir.
even if they are asking for more rentals, we'll pay it, but we want a breather for about 6 months. Because I've shown my bona fides, what are the efforts which we have been making. What
Yes, sir. Yes, sir.
another number of paper publications are given for this.
Yes, sir.
purpose.
Yes, sir. Oh, this is by the Punjab National Bank. Yes, correct. Yes.
Not just
So-
by state disposition temporarily, we will
Yes.
we will ensure that we will find a suitable accommodation.
Yes. Heard the Learned Council appealing for.
My lord,
Yes.
my lord, the.
See, now the bank is there. See, immediately they cannot be thrown out
No,
from
no,
the.
no, but not, it is not equal. Today, the matter is sealed up by the trial court. It is to pass an order. They have filed a similar application before that trial court and it is pending.
Sir, this is a
It
bank.
posted for
The bank is.
order spread.
See, bank is there. Punjab
My lord,
National Bank.
please.
They will pay you rentals, whatever the rentals that they will pay you.
Even without consent, I'm making a statement, Milords. From the last paid rentals, we will immediately pay 10% more from this month onwards.
Even they will get 10% more
No,
also.
no, my lord, please hear me. The suit was filed for eviction in 2015, my lord.
Yes, sir.
And they have given an undertaking. And that to a compromise petition,
Yes.
the decree was possible.
Absolutely right. But what will happen to shift the bank from one place to another? The requirement or they authorize they have to get a permission from the RBI.
But my lord, this they have had a time. In fact, they have.
They had time, but they were not able to get the permission from the RBI because it's a bank.
That is not the reason why.
See, it's not a private person one who is residing in a particular
They have not
place.
stated so in their petition. It is not the reason given. Reason given is that they have not been able to find a suitable place.
Yes.
Not because the RBI has not given the
Yes.
permission. They have not even applied to the RBI for a permission.
Absolutely right, sir. They need a
also
suitable
say
place
that-
to keep money and jewels and everything of our own people. They need a suitable place for that. We cannot send them to some other.
Since 2015, my lord.
No. Let us. We will see. We will accommodate them. We will stay the further proceedings.
At least the trial court should be allowed to pass the order. It may be in their favor. We don't even know about that.
In their favor means you say. I will.
No, that's
We
not
will communicate now.
possible that, it may
If
be
you say I
like
will communicate, we will communicate the court. Pass order in their favor.
No, that is not what I
That is
meant.
not possible. That's why please say. Just you say. Sorry. Further proceedings. Further proceedings in execution petition number
My lord,
2149 for 2021 on the file of the city civil judge is stayed. Yes, sir. So this is bank, sir. It's not private. Someone is residing in this very same place.
because of them.
It will be taken up immediately after vacation. Just after summer vacation. Yes. It's a bank that we have to accommodate them. That's why. Yes, madam. Complaints. Which one, madam?
When you fix the date, my lord.
No, it will be after the vacation. 2 weeks time is granted to comply with the office objections, if any. Yes.
Serial number 19, Sri Suraj Patil.
Yes, sir.
One office objection, my lord, with regard to my lord, they have not filed execution petition.
You are not fine.
My lord, because my lord have challenged the order of A number 3, final order are not challenged. That is why my lord, that office objection is kindly overruled.
Why? What your challenge here?
My lord, orders on IA number 3. IA number 3 is my lord to break open and my lord to dispose the petitioners from the premises.
Who are you before the court?
My lord,
Who are you before the executing court?
my lord,
You are the judgment editor.
please, my lord.
Yes, sir. What your challenge?
My lord, I have challenged the order on IA number
Order
3.
dated 14th March 2022. Where is that annexure A? You have challenged the order on IA number 3.
Yes, sir.
Yes.
My lord, one submission. What is happening?
What is the office objection?
My lord, execution petition copy I have not filed. That is the
That is requirement. That is required.
my lord.
That's required actually.
I'll file, my lord, if I kindly give it for one. My lord, the urgency is, my lord.
No urgency. Just
My
it's-
lord, one submission.
Comply with execute without execution petition is filed. How can say? 1 week's time is granted to comply with the office
My lord,
objection.
kindly hear me for 1 minute, my lord. My lord, what has happened is, my lord, 25th of March I filed writ petition, my lord, they were on caveat, my lord. I have said,
First you file.
my lord, one submission, my lord. My lord, what I have already been thrown out with premises. That is the urgency. Because what has happened is, 25th I filed writ petition. Because after that, after 2 days, on Monday, that's on 28th, he takes police protection, knowing fully well that I have filed a petition. He takes police protection, come to the premises, he disposes me, he throws me out. My goods are outside now. I'm totally left on the streets. I have no place to go as of now. It's the only business I have. That is the urgency. And today, the matters before the trial court.
Yes, very well.
That is why
Execution, without filing the execution petition, how can you? See, 25th you filed it. You should have filed it by this time. You took more than 10 to 12 days just to file the execution petition. 2 days time is granted to comply with the office objection. If the office objections are complied with, list on Monday. Let us will take it.
Serial number 20.
2 weeks time is granted to comply with the office objection.
Serial number 21.
Same order.
22.
Yes, same order. No, 2 weeks, not 1 week. 2 weeks will be granted.
Serial number 23.
Yes, 2 weeks time is granted to comply.
For the petitions. But there is one objection, my lord, with respect to NHRF. Type copy of the manuscript portion of the NHRF to be furnished. My lord, we are relying only on page number 87 and 81 of the issued order.
Correct. Yeah. Yes, sir. You
Serve
serve.
copy.
You serve then. Lana Council appearing for the petition is permitted to serve copy of the writ petition to the Lana Council appearing for the caveator / respond number 1. Yes. Excepting the submission made by the Lana Council appearing for the petitioner, office objection is overruled.
And also there is a note, my lord, below cost item.
Yes.
Defendant number 1 is type, my lord, and they are not made him as a party.
Respond number?
Defendant number 1, my lord, in suit.
Yes, sir.
They have not made him as a party, it's the injunction suit, my lord.
Yes. Why?
My lord,
We are not seeking any relief?
no. We are defendants. They are challenging the
Slowly. Lana Council appearing for the petition further submitted that the petitioners herein are not seeking any relief against the defendant number 1, and in that matter, the office objection is overruled. List on Wednesday. List on Wednesday.
Serial number 24.
Lordship, kindly see exhibit office objection is recorded. Annexure F1, page number 62.
Yes.
It is
Yes.
the order sheet of this honorable court in criminal petition. Can I just
Correct.
take Lordship, page number 62?
1 minute, sir. 1 minute.
The first copy the type in computer typed copy. The second one is handwriting.
F1, page number, sir?
Page 62.
62. Yes, sir.
This is typed copy. Another one is only I am not referring to this what's called document in the course of my
Office accepting the submission made by the Lana Council appearing for the petitioner, office objection is accepted.
Can I make my
Office objection is overruled. Yes, sir.
Can I just your Lordship, kindly is a very small matter now. I have filed what is called suit has been filed against me in what is called seeking a money suit for 2 crores and all. I have paid the entire amount. Your Lordship may kindly see that he had filed a criminal case and also a civil court. In this, by this order, this honorable court passed an order. Granting me time up to 30th of December to pay the entire 2 crores rupees. I have complied with that order. Nothing is due to the petitioner now. Your Lordship may kindly see that an attachment order has been passed. That order has been passed without following the procedure. Your Lordship may kindly see that now. Nothing is due to the what is called respondent now. I have been trying to what is called in the court below to get this matter to get what's called to argue this matter and get this what's called order disposed of now.
What is the impugned order? What is the impugned order?
Can I just take your Lordship to page number 24? Lordship, KMD come to 24.
Order date of 4/12 is challenged now.
Yeah, that 4/12 was there because I had not paid the money. I paid the money and afterwards I have filed an application for discharging the order of attachment before judgment. Entire amount. What
is the order dated 4/12?
Your Lordship may kindly come to 24. The court has passed an order. Is order 38 towards attachment order. Can I just take your Lordship?
So what is the 4/12 order? What is the 4/12 order? 4/12/2019 order.
And your Lordship, there is a 4/12 order itself is there. That is the order. That is the passed under order 38/5. By that time, I had
which page number? So which name page?
That is page number running page page 24.
24.
Yeah.
The order is passed in 2019.
Yes.
And the writ petition is filed in 2022.
Reason is that I paid the entire amount of 1,94,000.
I can issue emergent notice letter. I will hear the other side and pass it.
Your Lordship, can see
No, there is a delay of 2 years. There is a delay of.
No, I filed this because I wanted to make sure that to pay the entire amount as per the order.
Maybe sir, there's a delay of 2 years in challenging the order.
No,
issue emergent notice to the respondent.
Lordship may kindly fix some dates.
You serve copies and it will be taken up also. The counsel appealing for the petition is also permitted to serve copy of the writ petition to the learned counsel representing the parties for the trial court. Yes, sir.
Can it be called next week, Lordship?
Next, it will be taken up on 21st, sir. 21st. 21st. List on 21st. By the time you can serve copy to the
I'll just do that, no problem.
Yes.
Serial number 25 is petitioner challenge.
2 weeks time is granted to comply with the office. 1 week's time is granted to comply with the office.
I am applying for R2.
Yes, it will be taken. Yes, 1 week's time is granted. 1 week's time is granted to comply with the office objection. Yes.
Hearing on IA, serial number 26
Yes.
is Dinesh.
What is this? Sir? Yes. Application. File. Application. We will recall the order. No, this is filed by the advocate. I think he was not able to appear on particular day. All this. It will be. It will be taken up on Monday. Excepting it was shown in the affidavit accompanying the application, filed by the petitioner today in the court today, the order dated 10/12/2021 is recalled, and the writ petition is restored on file. It's a list on 18th.
Serial number 27 is Malappa PM.
Please, my lord.
Yes, sir.
Please, my lord. Now, writ petition by the defendant.
Yes, sir.
Respondent filed suit for partition.
Yes, sir.
Lord, I filed return statement.
Yes.
In the return statement, Lord, I contended that, Lord, under a registered partition, Lord, the suit properties were divided.
Yes.
And in view of that, Lord, I filed application under Order 7 Rule 11 A and D.
Yes, sir.
Lord, my application came to be rejected by the trial court. Lord, the
Yes,
earlier
sir.
partition, Lord, under registered partition, that has not been taken into consideration by the trial court.
Yes.
In my Lord, considering the application filed under Order 7 Rule 11.
Yes. You are much aware. But only thing is, it has to be looked into only in evidence.
No, the father
Because
of the father of the plaintiff is the signatory to the document.
Maybe
She has not
true,
direct.
but
No counter is filed. No counter is
Yes.
filed. Lord, if
Yes.
she filed a
But
counter
insofar
saying
as
that,
but insofar as Order 7 Rule 11 is concerned, only the averments in the plaint has to be looked
that
into.
is, Lord, my return statement. I had my defense. She has,
No, not written statement. Not written statement. Plaint.
Lord, she claims partition, saying by suppressing
Maybe
the
true, sir. Maybe
partition
true.
taken place.
Even otherwise, so it's a very drastic situation. If the plaint is rejected based on the averments made in the defendant, it leads to a drastic the change in the.
My
So
submission,
it's a
Lord,
very
my
stringent
submission.
one.
If really, Lord, she files a counter and she had, Lord, her say in the matter, Lord, contrary to my return statement, certainly, Lord, what this honorable court finds, Lord,
Those aspects, those aspects have been considered only in the evidence. She alleged that there is a fraud.
No,
She
she
alleged
has not.
even the-
No. I can read the plaint. I can read the plaint.
Yes.
She never challenged it.
Because no. She said the said partition was effected without her knowledge.
No, she can't have any knowledge because her father is a party.
Maybe true.
She can't be considered as a necessary party to the partition because
Yes,
it is the partition in between the brothers of the father and his brother.
Yes, sir. I think not a case for interference. In Order 7 Rule 11.
At least, Lord, I can request the court at least direction to the trial court to speed up the matter because
that could be done. That could be done.
Please,
yes,
please.
Sorry. This petition is filed by the defendant in OS number 512 of 2016 on the file of the additional civil judge in JMFC at Kunigal, challenging the order dated 13th November 2020, dismissing the IA number 6 filed under Order 7 Rule 11 within bracket D, close the bracket of CPC. Please rise. The respondent number 1 is the plaintiff before the trial court. The plaintiff has filed suit seeking relief of partition and separate possession in respect of the suit scheduled properties. On service of summons, the defendants entered appearance and filed a written statement. The defendant have also filed IA number 6 and Order 7 Rule 11 within bracket D of CPC, seeking rejection of the plaint. The said application was resisted by the plaintiff. The trial court, after considering the material on record by its order dated 13th November 2020, dismissed the application in IA number 6. Feeling aggrieved by the same, the defendant has presented this petition. I heard Sri Siddhamallappa and a counsel appearing for the petitioner and Mr. So-and-so and a counsel appearing for the respondent number 1. Sri Siddhamallappa and a counsel appearing for the petitioner contended that the father of the petitioner and the defendant and the plaintiff and the defendant has executed the registered partition deed dated 18/12/1993 and pursuant to the same, the properties have been devolved between and among the children among the parties to the suit, and the said aspect has not been brought to the notice of the court, and therefore the finding recorded by the trial court requires to be interfered in this petition. Per contra, Mr. So-and-so and a counsel representing the respondent sought to justify the impugned order. Undisputably, the relief sought for by the plaintiff is partition and separate possession in respect of the suit properties. It is the case of the plaintiff that the petition is entitled for her legitimate share in the suit property in terms of Section 6 of the Hindu Succession Act 1956. Though the defendant have taken a plea in the written statement that there is already a partition deed dated 18/12/1993 with regard to the scheduled properties. However, the same has to be decided only after full-fledged trial, since the plaintiff has taken a plea that the scheduled properties are to be partiable in nature. It is also settled position of law that by the Supreme Court in the case of so-and-so reported in 2015 8 SCC 331 that the court should be very slow while accepting the application under Order 7 Rule 11 of CPC, as same is of drastic in nature, and the condition precedent for exercising the such power by the trial court is very stringent, and the trial court shall look into the averments in the plaint alone. And in that way of the matter, I am of the view that the finding recorded by the trial court is just and proper. It does not call for any interference in this petition. However, considering the arguments advanced by the learned counsel appearing for the parties, and the suit is of the year 2016, seeking relief of partition and separate possession in respect of the suited property, the trial court is requested to expedite the hearing. Accordingly, the petition is disposed of. Yes, sir.
At least not 1 year time.
No, sir, no, sir. I don't know how many matters are before the trial court. It's very difficult.
Is 1 year, it is.
No, sir. That I don't want to put pressure on the trial court.
Please,
next
please.
please. Yes.
For seeking police assistance to implement the order and rejected by the trial court.
Yes, sir. What is the error committed by the trial court actually?
When the order has to be implemented, which has been granted by the trial court itself, in order to the order of injunction.
Where is the injunction order passed by the trial court?
Injunction order.
Yes, sir.
It is in page number. Page number 23.
23.
Operating portion is in page number 37. A filed application for this order will the respondent 1 as preferred MA. Lordship in MA number 6. In that
this is filed by the defendant.
Is as a counterclaim.
Third, this petition is filed by the plaintiff, defendant number 4, in OS number 48 of 2019 on the file of the Principal Civil Judge Veeraj Pete, challenging this petition is filed by the defendant number 4 on the file of the Principal Civil Judge Veeraj Pete, challenging the order dated 4th December 2020, allowing the IA number 7, which is that order, order
number
15.
23.
There are two orders. Which order which came to dismiss? Annexure A. That is a annexure A.
Annexure A in page number 15.
Yes. Order dated 16th August. Order dated 16th August 2021. Command dismissing the IA number 13 filed by the defendant number 4. Brief facts for adjudication of this petition are that the plaintiffs have filed suit against the defendant seeking relief of where is the plaintiff, sir? Seeking the relief of
page number 39 for declaration and possession.
Seeking relief of declaration with consequential relief of permanent injunction restraining the defendants from interfering with the associative properties. The defendants entered appearance and filed detailed written statement and also pleaded counterclaim against the plaintiff under Order 8 Rule 6A of CPC. In the meanwhile, the defendant number 4 has filed application in IA number 8 under Order 39 Rule 1 and 2 of CPC seeking temporary injunction against the plaintiff from interfering with the peaceful possession and enjoyment of the counterclaim scheduled property. The trial court, by order dated 4th December 2020, allowed IA number 8, restraining the plaintiff from interfering with the suit scheduled property. Thereafter, the defendant number 4 has filed IA number 8 under section 151 of CPC seeking police help to restrain the plaintiffs with interfering with the suit scheduled properties, and the said application was objected by the plaintiffs. The trial court, by impugned order dated 16th August 2021, dismissed the said application and feeling aggrieved by the same, the defendant number 4 has presented this writ petition. I've heard she so and so and a counsel appearing for the petitioner. You make state as a party. You order sheet of the court. Then a counsel appearing for the petitioner is permitted to array the jurisdictional police as the defendant, as the respondent number 6 in the writ petition. SCGP is directed to take notice for respondent number 6 order sheet. Then SCGP, the respondents are served in the writ petition and remained absent. Full stop. Then SCGP submitted that the impugned order passed by the trial court is just and proper, and in the event if the plaintiff violates the order of the injunction granted by the trial court, the defendant number 4 may initiate contempt proceedings against the plaintiffs, and accordingly she sought for dismissal of the writ petition. In the light of the submission made by the Lana Council appearing for the parties, I have carefully considered the pleadings on record. It is not in dispute that the plaintiff has filed a suit seeking declaration with the consequential relief of permanent injunction restraining the defendants from interfering with the associative properties. However, in the meanwhile, the defendants have filed written statement taking counterclaim against the plaintiff. Perusal of the order dated 4th December 2020 by the trial court within bracket annexure B would indicate that the trial court has restrained the plaintiff from interfering with the suit scheduled property of the plaintiff, of the defendant number 4. The trial court, however, justified in arrive at a conclusion that the defendant number 4/petition hearing may resort to file contempt proceedings against the plaintiff for violation of the police help. However, taking into account the law declared by this court in the case of so and so, reported in ILR 2010, Karnataka 1197, I am of the view that in the peculiar circumstances of the case, I'm of the view that the police help be required to restrain the plaintiff by the defendant number 4. And in that view of the matter, I'm of the view that the finding recorded by the trial court dated 16th August 2021 is set aside. IA number 8 filed by the applicant slash filed by the petitioner slash defendant number 4 is allowed. Accordingly, the petition is disposed of. Any judgment you refer to? Give me one judgment. Which is that?
This is the Papanna versus Nagadeo. It is 1984.
Give me that. You amend it? Yes, sir. In all the time, police help cannot be given, but in a given that depends on the facts.
Please.
Petition just I will add it today. Add market. I will add it.
Serial number 29. Revan Siddhappa. Revan Siddhappa.
Yes. Who is for the respondents? Vacate the interim order, it is there. But who has filed? There is no respondent. Vacating is there, but it's not shown. Who has filed it?
Mr. Randaram advocate has sent us a copy.
But whether he has filed power? Yeah. No Vakal. I think list after. Yes, list after vacation. Just a minute. Torsilala. Just a minute. Padikadi. Registry is directed to print the name of Mr. So-and-so. V. Rangaramu and Associates. Representing the respondent number 1 and 2. In the cause list, interim order granted earlier extended till next date of year. Yeah. Yes.
Preliminary hearing matter, serial number 30.
Yes, sir.
For declaration for special exemption. The IA number 1 was filed. The order the same defendant from
yes, sir.
Serving the standing crops and the compound guard. His application came to be allowed on merits. Thereafter, since there was
but the MA is pending consideration before.
pending consideration, it was not decided. If of the petitioner got is that IA number 3 came to be allowed, notwithstanding the fact that on the very same day IA number 2 was allowed, no notice of this IA was served on the petitioner.
And it was struck down. Order sheet is struck down.
Yes.
And thereafter one more order is passed by the trial.
Yes.
Third, issue emergent notice.
Alert, I have already served the copies to the connected matter.
Let us issue emergent notice to the respondent. Come on. Order dated.
8/3.
Which is that order?
8/3/2021. I'm sorry, 5/3/2020.
Order dated 5/3/2021 is stayed till next date of year. On IA number 3.
Already served copies of the
On IA number 3, filed by the respondent number 1 and 2. Yes.
They already entered appearance on
in this petition.
Yes.
Yes. No. They are not represented.
like shows that they've already, because I've served the copy on 28 to.
Sir, serial number 31.
Yes.
30 lakhs.
I'll accept it.
Yes. Emergent. Yes, sir.
State petition 8247 of 21.
Along with this.
Like connected matter. On the same day, in the order.
Just along with WP number.
8247 of
Please.
21.
Note point.
47 of 2020.
Yes.
Serial number 31, Sri Jawahar Babu.
In this matter.
Yes, sir.
I beg to appear for the petitioner.
Yes.
That the petitioner has taken back the file with no objection in das wakalat on
Yes.
16th March 2022.
Yes.
I have filed a memo
Yes,
duly signed by.
Yes, sir.
I have filed a memo on 17th itself.
It's a divergent opinion, sir. Divergent opinion. Divergent opinion. Divergent opinion by the first appellate court, actually. So the parties may be directed to maintain status quo. Yes, sir.
Yes, filed.
Just a minute. You are appealing for?
Petition. Yes, given a inverse wakalat. I have filed inverse wakalat on behalf of petition.
Oh, you have filed. I think very well.
It may be permitted to retire minutes. I
Yes.
have filed a memo on 17th.
Sorry. You, Mr. Varun, yes. Submitted that he has entered appearance on behalf of the petitioner, and therefore the registry is directed to delete the name of Sri V. Jawahar Babu, Learned Counsel appearing for the petitioner, and print the name of Mr. Varuna R. Learned Counsel appearing for the petitioner. Full stop. Yes. Status quo. Yes. Issue emergent notice. Parties to maintain. Parties to maintain the status quo insofar as suit schedule properties is concerned. Yes.
Serial number 32, ordinance serial number 33, Sri Dushyant Aradhya.
Yes, sir.
Now, petitioner is the plaintiff before a trial court. Now, defendant is the tenant, my lord.
Defendant is a tenant.
Defendant is tenant.
Huh.
Now, my lord, the case is originally the defendant was the owner of the property. Now, he had executed a registered sale agreement in my favor.
Yes, sir.
First, a sale agreement, my lord. The CAT was also executed.
Yes.
And thereafter, a rent agreement was also executed when he said that continue as a tenant in their property.
Yes.
Rent was fixed for a sum of 80,000.
Huh.
Now, meanwhile, my lord, after 2 months, my lord, he became a chronic defaulter of paying of rent.
Yes.
Now, this suit, my lord, I will issue a notice to him. He doesn't respond to the notice, then I file his suit.
Correct.
Meanwhile, I have sought for application 151, my lord, I have sought for arrears of rent. Now, trial court, my lord, comes to
Whether he has entered appearance?
yes, my lord, he has entered.
Where is the written statement?
My lord, the objection statement, my lord.
Whether he has questioned the relationship between jural relationship?
Yes, my lord. He says that.
Then?
And one factor, my lord, for consideration. He doesn't challenge this sale deed executed in my favor. He remains silent about
Maybe
this factor.
this is a suit filed by you for eviction.
But he is
Not he.
I do agree, my lord.
We cannot force a defendant to file a suit against you.
But he is not challenging my sale deed. Now, merely on a statement saying that I have not executed the sale. He doesn't say that.
Anyway, he has pleaded in the written statement that he has questioned that you are not a owner of the suit property.
No, he doesn't say that. So. He says, I am not executed sale deed in the favor of the plaintiff. But as far as rent agreement, he remains silent. So that is why this application was filed for the trial court, my lord. Now, even in the statement of objection, my lord, at page 46, he says, I am not executed sale deed. 1 crore 90 lakhs was given to me as loan.
Yes.
He admits the fact that 1 crore 90 lakhs was given, but he says it is loan. And there are
You file another suit for another different cause of action.
It's a complaint.
The reason that you are not filed because you have to pay court fee.
I am seeking for arrears of
If you claim 1 crore and odd, then you have to file. You have to claim. That's why the sale deed is not. That's why you filed a suit for eviction. In the eviction, you sought for payment of rentals.
Yes, ma'am.
Going around the bush. That cannot be done. That
From
cannot.
the date when the suit was filed.
Very well. Even
During
otherwise.
pregnancy, the enjoyment
Even
of
otherwise.
property, ma'am.
Maybe true. Maybe true. Go straight line. Not
The
deviation.
enjoyment property without paying.
Maybe true. Maybe true. You file one more suit. You yourself can challenge it. You allow him to file because in the event if you file, you have to pay court fee. Huh? That may be the reason.
Not contesting the matters of the trial court, he files the
No,
objection, he remains
no.
silent.
Maybe true.
Now, the way purpose of me filing this suit, my lord, is stated and
No, nothing will happen.
past 2 years, my lord, continues for 2 years.
Nothing will
He is not paying the rent. I'm
Yes,
not
you expedite the hearing better, I think.
With that observation, my lord,
You expedite, not because it's 2020. It's only a 2020 suit. Just now, for us.
even otherwise, the
This
full purpose
expedition,
of serving the purpose of
nothing.
justice, my lord, will be taken away. My lord, the clients have to go when there's a legal right which is being violated.
Yes.
And even otherwise, my lord, you have to
You take appropriate steps known to law. That's all.
I do
This,
agree, my lord.
this
Only
petition
one
is filed by
observation
this
my lord,
no.
comment.
That cannot be done. That cannot be
My
done.
lord.
We cannot direct them to pay the rent. This
Not the
petition.
rent, my lord. My only request is this. Let the trial court, my lord, expose the matter.
No. This is 2020. I don't know how many matters are before the trial court. I don't know how many matters on his board. So each case, if you do like this, so there will be a injustice. Injustice may cost to the.
Not with any time bound matter. I'm not saying for that.
If it is more than 5 years, I can look into it. It's only 2 years. See, procedure has to be followed. This writ petition is filed by the plaintiff in OS. Please run in OS number 1954 of 2020 on the file of the 10th Additional City Civil Judge, Bengaluru, challenging the order dated 27/1/2022. Yes.
I don't want trouble the court, my lord. I'll withdraw the case.
After arguing for some time, Sulana counsel appearing for the petitioner seeks leave of the court to withdraw the petition. Accordingly, submission is accepted and the writ petition is dismissed as withdrawn.
Great.
Area 10:30 it moved on. No, ready. I will take it up now. See, in suit for partition suits, you cannot file an applications for prove the paternity in DNA test. See, you're all brothers and sisters. You take it. I will take it up now. It has to be dismissed with cost, so that in any other partition matter, such a thing should not be happening. 32 only. I will take it up now.
Council is
No.
personal
In the, then you can. Then don't worry at all. Don't worry. Then don't worry. Rest after vacation. Just no, intermatter cannot be. You argue, I will take it up. Yes, intermatter illa anta ನೋಡಿ. ಇದೆಯಾ? ಮಾಡ್ಕೊಟ್ಟಿರ್ತಾರೆ. Just 1 minute. Because all further proceedings have been stalled now. Shall I take it up or pass it? Very good. Pass it. Very well.
Serial number 34, Sri Lakshmikant K.
Yes, sir.
The petition is a different for the trial court.
Yes.
Plaintiff may not has filed application on 11 Rule 5.
Order 11 Rule 5.
Seeking to produce the original bill.
Annex E.
Please, Annex E.
Yes, sir.
Seeking a direction to produce the original against the defendant. The defendant has taken a contention that the will itself is not executed, and he doesn't know that the will executed by the father.
Now you have been directed to
Produce the original.
original.
Which is not because
Which is not? Which is not in your custody.
It is not in my custody.
Yes, sir.
That application is considered by the person direct me to produce, which is not at all.
Who has executed the will, sir?
The father of the plaintiff.
Father of the?
Plaintiff. That the dated 11/7/1994.
Father of the plaintiff.
Please.
Father of the plaintiff means your father.
Father of the plaintiff as well as the father of the plaintiff.
Father of the plaintiff means your father only. Yes. That is, you are also defendant. Then you can have then the Xerox copy may be taken into consideration in the event if you do not produce.
The Xerox copy is also produced. And the secondary.
As a secondary, because already they have laid a foundation in the plaint itself. The copy of the registered will is with you only. Yes, what is error committed by the trial court?
Will is not with me.
Yes.
Because initially before signing the suit, the plaintiff has issued a notice to me.
Let us issue emergent notice. Issue emergent notice. Yes, nothing. Let us issue emergent notice. Yes. Plaintiff before a trial court. Yes, sir.
The plaintiff has filed a suit for declaration and a consequence for injunction.
Yes, sir.
Case of the plaintiff before the trial court, the father of the plaintiff
Yes.
has purchased the property in the year 1992 on 23/1/1992 through registered sale deed with respect of said property.
Yes.
From defendant's number one father.
Yes.
That is Ramanayake.
Yes, sir.
The registered document is there. Thereafter, they have put up construction, then they have put up the trees and everything.
Yes, sir.
And also put up a fence in the around the area.
Yes, sir.
The defendant's property is adjoining to the plaintiff's property.
Yes, sir.
They have requested after the death of the father of the defendant, they have requested the plaintiff, the LRs of the Maranayaka, then they have allowed the defendants to carry out the building materials through their site.
Yes, sir.
It is
Yes, sir.
absolutely a permissive position now.
Yes, sir.
Since the father of the defendant was illiterate, he has not applied for government checking for records, for
Yes, sir.
contracting other things.
Yes, sir.
Taking advantage of it,
Go to para number 15 of the order passed by the trial court, not a first appellate court, page 41.
First appellate court.
Yes, sir. No.
I have
Trial court order, not first appellate court, trial court order. Para 15, page 41. That you have not produced any document to prove your position.
I have produced the safety.
Maybe.
Then a police complaint was produced.
Yes.
The Honorable Trial Court heard that, the First Appellate Court heard that the copy of the safety has not been produced. But in the para number 12,
Yes.
para number 12, they say that the
Even that apart, what is the material that you produced to show it that
I have produced
you are in possession?
I have produced the register sale deed, wherein on the date of register sale deed, position was delivered.
To you, that may be there always.
That may be there.
But what about the subsequent?
Subsequent is the police.
Sale deed is of the year 1992.
Encumbrance certificate has produced.
Yes. Encumbrance says only insofar as the transaction. That is in 1992. What about 2018? No document. No document. Both the courts are right. Totally. This petition.
I have also relied upon the one judgment.
Yes, Kodi.
Because the
Kodi.
Order 39 because when the register sale deed is there, the defendants cannot deny the execution of the sale deed by father.
Yes.
Because as on the date of register sale deed, position was delivered, consideration was accepted.
Yes. Yes.
So I have become the absolute owner of the property.
You are absolute owner, but what about possession?
Position is already
No document. No document has been produced.
Permission to the LRs of the defendant.
Yes.
Only to take building material.
Yes, Sidbala, sir.
Please, Lord, my submission is the suit is for declaration and permanent injunction. They have not sought for recovery of position. Their contention is that they have allowed us to continue in position.
Possession, that's right.
Please.
That's on that score only in for first appellate.
Both the courts, my Lord, clearly finds, my Lord, that they are not in position.
Please, This writ petition is filed by the plaintiffs.
The trial court found that trial is necessary.
Yes. Let there be a trial, sir. This writ petition is filed by the plaintiff, challenging the order dated 31st August 2021 in MA number 13 of 2021 on the file of the second additional senior civil judge and JMFC at Tumakuru, dismissing the appeal and as such confirming the judgment and confirming the order dated 23/3/2021 on IA number 1 filed by the plaintiffs under Order 39 Rule 1 and 2 of CPC in OS number 676 of 2018 on the file of the second additional civil judge and JMFC, Tumakuru. The relevant facts for the adjudication of this writ petition are that the plaintiff has filed suit against the defendants seeking relief of declaration with consequential relief of permanent injunction, restraining the defendants from interfering with the suit property. The defendants entered appearance and filed written statement. In the meanwhile, the plaintiffs have filed, The plaintiffs have filed application under Order 39 Rule 1 and 2 of CPC, and same was resisted by the defendants by filing objection. The trial court, after considering the material and record, by order dated 23rd March 2021, rejected the application, and being agreed by the same, the plaintiffs have filed MA number 13 of 2021 on the file of the First Appellate Court, and the First Appellate Court, after considering the material and record, by impugned order dated 31/8/2021, dismissed the appeal, and as such confirmed the order dated 23/3/2021 by the trial court, full stop, in OS number 676 of 2018. Feeling agreed by the same, the plaintiffs have preferred this writ petition. Suresh P. Lana, counsel appearing for the petitioner, argued that the finding recorded by both the courts below is contrary to the records, as the plaintiffs have purchased the suit schedule property through registered sale deed dated 23/1/1992, and therefore the finding recorded by both the courts below requires to be interfered with in this writ petition. Per contrast, Sri Siddhamallappa, PM Siddhamallappa, Lana counsel appearing for the respondent number 2, sought to justify the orders passed by the trial court and submitted that the plaintiffs are not in possession of the suit schedule property, and they are not sought for the relief of possession in the suit, and therefore the trial court, taking into consideration the material on record, dismissed the IA number 1, which requires to be affirmed in this writ petition. Having heard the learned counsel appearing for the parties, I have carefully considered the material and record, wherein the trial court, wherein the suit is filed by the plaintiff seeking relief of declaration with consequential relief of permanent injunction. The said relief sought for by the plaintiff itself indicate that the suit is filed based on the registered sale deed dated 23/1/1992. However, the finding recorded by the trial court that the plaintiff are not in possession of the suit property and no material has been produced before the trial court to evidencing their possession, as on the date of filing of the suit. And in that way of the matter, both the courts below have arrived at a conclusion based on the material and record that the plaintiff has failed to prove the prima facie of possession in respect of the suit schedule property. And since the granting of the granting or refusal of the temporary injunction is a discretionary nature, and as both the courts concurrently held against the plaintiff, and in that way of the matter, interfering with the same by exercising jurisdiction under Article 227 of the Constitution is very limited, and therefore the plaintiffs have not made out a case for interference with the well-reasoned orders passed by the trial court. Accordingly, the writ petition is dismissed as devoid of merits. Yes, sir? Yes. Other contentionally, plaintiff contention. We also relied upon the judgment of this court in the case of A.N. Nagarajaya versus B. Arvind and others, reported in AR 2014, Karnataka 140, and the perusal of the principle laid on by the case in the said judgment, wherein, Section 54 of the TPA Act was pressed into service in the said judgment, and also relief of part performance as held out in Section 53A of the TPA Act is also taken into consideration. However, in the present suit, this relief sought for by the petitioner is claiming relief is the declaratory in nature, and the onus lies on the plaintiff to prove the case on merits through cogent material and record with regard to the possession, and in the absence of the same, the trial court and therefore in the absence of the same, the judgment referred to by the petitioner cannot be accepted in the facts and circumstances of the case related. Yes. Yes. What is impugned order, sir? Order dated 23/2 Allah.
And to further cross-examine the witnesses on behalf of the plaintiff.
Yes, sir. Issue emergent notice. Not a case for stay. Court has given the sufficient para 9. Court has given sufficient time to defendant cross-examine PW1. Court has allowed the application filed by the attorney to recall earlier. This is the second one. Just let us will give issue emergent notice. You go to impugned order paragraph number 9. Earlier the chance was given to you, and you fully cross-examined the PW1 and 2. Let user issue emergent notice. Lana counsel appealing for the petition is also permitted to serve copy of the writ petition to the Lana counsel appealing for the respondents. Yes.
Dispensation of notice
to
respondent 229. They are the co-defendants along with the.
Sorry, Lana counsel accept. Lana counsel appealing for the petitioner filed memo seeking dispensation of notice in so far as 2 to 9. Full stop. Memo is accepted at the risk of the petitioner. Yes. Notice 2 to 9 is dispensed. No, nothing. Nothing will happen, sir. I think it twice already given. This is third. Let there be an opportunity. Yes.
Serial number 37,
Yes. Yes. 61.
The facts of the time 96.
Sorry. issue emergent notice. Stay of further proceedings in FDP number 6 of 2019.
Wrong person has filed.
Wrong person. Even I don't know how come.
No, so even the partition did not given. His sale deed was cancelled in the partition.
I don't know how the court has arrived.
Yes.
Stay of further proceedings in FDP number so
I will give
on the
memo
file.
because final decree proceeding will be drawn. I will give memo for.
Then it will be released today.
Yes.
It will be released. Yes.
Serial number 38, Sri P.K. Manjula.
Case for the petitioner.
Yes.
Filed by the petitioner matter for declaration.
Declaration.
That the sale deed.
Yes.
Executed may not in respect of his share may not is not binding.
Yes.
Then they filed an application for injunction against the defendant. Injunction was granted, may not restrain injunction, may not
Yes.
be alienated.
Yes.
Thereafter, they started cutting and removing the trees may not existing on the fruit land.
Yes. Yes.
Then we filed another application. The trial court granted may not temporary injunction, restrain the defendants not to cut and remove.
Yes.
No matter after the evidence was recorded, may not an application was filed by the petitioner.
Yes.
May not under order 16 rule 1.
Yes.
May not requesting the court may not to summon the sub-registrar.
For what purpose?
Because may not the property was sold for a very low price.
Yes, very
And the
well.
learned judge
For what?
to give evidence.
That
to give
cannot be.
evidence.
For that
Because
purpose, if the registrar is summoned,
what has happened with
Yes.
this Melad? You could not get any documents. And then Melad, the learned judge rejects the application on the ground I have not pleaded in the plaint.
yes.
Kindly see in the plaint Melad I have produced.
Even otherwise, even that apart, I will leave apart. Even for that, if whether consideration is, see, it's only the people will present a sale deed, he will register it.
Valuation gets some
Nothing. Even that is a statutory application that you can. For that purpose, the registrar cannot be.
Valuation
No,
only
sir.
Melad.
No, sir.
That's all.
Not a case. For it. Yes. Please sit down. Please sit down. This writ petition is filed by the plaintiff in OS number 7 of 2018 on the file of the senior civil judge and JMFC Tirthahalli, Shivamogga, challenging the order dated 16/3/2022, rejecting the IA number 31 filed by the plaintiff, 13 filed by the plaintiff. Full stop. The relevant facts for the adjudication of this writ petition are that the plaintiff has filed a suit for declaration with the declaration that the registered sale deed dated 17/12/2019 is void and not binding on the plaintiff, and also sought for such other relief set out in the plaint. The defendants entered appearance and filed a detailed written statement denying the averments made in the plaint. After the completion of the evidence of the parties, the plaintiff has filed application and order 16 rule 1 and 1 read with section 151 of CPC to summon the proposed witness within bracket sub-registrar Tirthahalli, close the bracket, to give evidence on the registered sale deed. The said application was registered by the defendants. The trial court by impugned order dated 16/3/2022 dismissed the application, and feeling aggrieved by the same, the plaintiff has preferred this writ petition. She B.K. Manjunath, Lana counsel appearing for the petitioner, argued that the evidence of the proposed witness dash sub-registrar Tirthahalli is required to prove the case in the matter whether at the time of the registration of the alleged sale deed, whether the consideration given in the sale deed is undervalued or whether it is in accordance with the market value whether it's in accordance with the guidance value, and to prove the same, the evidence of the sub-registrar is required. And accordingly, he submitted that the finding recorded by the trial court declined to entertain the IA number 31 is bad in law, and therefore he sought for interference of this court. In the light of the submission made by Sri B.K. Manjunath and counsel appearing for the petitioner, I have carefully considered the application accompanying affidavit in IA number 31, which would establish the fact that the sale deeds sought to be nullified in the suit by the plaintiff is registered in the year 2006. In 2009, and undisputably the suit is filed for seeking partition and separate possession in respect of the one share in the scheduled properties. The trial court, taking into consideration the material on record, as well as the fact that the initial burden is on the plaintiff to prove that the said alleged registered deeds are not registered, taking into consideration the guidance value, and therefore the finding recorded by the trial court, decline to entertain IA number 31 is just and proper in the facts and circumstances of the case, and therefore I am of the view that there is no perversity in the order passed by the trial court, and accordingly the writ petition is dismissed as devoid of merits.
I appear for petition.
Yes, sir.
Suit for declaration and possession has been filed by the respondent.
Yes, sir.
This writ petition against the orders of the trial court in respect of rejection of Order 6, Rule 17.
Yes, sir.
Filed by the defendant.
Yes, sir.
The trial court has given a wrong finding, my lord. It is nothing but a final judgment. In page number 19, my lord.
19. Yes. Where is the application, sir? What you sought to amend in the written statement?
Amendment. What was happened, my lord? Earlier, the suit was filed by the defendant against the CMC. In that suit, my lord, the documents, all documents are produced in the OS 297 of 2007.
Whether you are a party in the said suit?
Yes, my lord. Yes, my lord. I have filed the suit as against the CMC.
Then you are aware about the fact in the 2007 itself.
That in that suit, my lord, all the documents are.
Then you are aware about, since you have filed the suit, you are well aware about the entire documents pertaining to OS number 297 of 2007.
Yes, please, my lord. Yes. Therefore, I have filed an application for secondary evidence because the documents are not available in OS 97 of 2007. That application was rejected by the trial court, my lord. Thereafter, this writ petition, this amendment of written statement has been filed.
Yes, on the ground that at the time of the filing of the written statement itself, you are well aware about, because this is a suit filed by yourself only.
No. Suit filed by the respondent.
Shivanna.
Yes, please, respondent.
Respondent.
Girijamma.
Yes,
Girijamma has filed the declaration and possession, my lord.
Yes.
But the trial court judge wrongly assumed that in page number 19, my lord, I have to prove the declaration title.
Whether the documents ought to be produced by you or the title deeds.
No, my lord. In respect of possession is concerned, my lord. It is because the plaintiff has claimed the possession, declaration and possession.
Yes.
Possession is concerned, the documents are very much required in order to give proper justice to the party.
Let us please issue emergent notice.
Lordship sought for
no, sir. Not at this stage of proceedings.
The trial court is in a very hurry.
You, sir, learned counsel appearing for the petition is also permitted to serve copy of the writ petition to the learned counsel representing the parties before the court below. You can move it, sir. Yes. Yes.
But the case of allowing amendment application at the stage of final arguments, an application was made by the plaintiff seeking to amend the prayer portion without even displaying the extent of due diligence. The application came to be allowed by the trial court on the sole ground that courts have wide powers to allow amendment.
Correct.
And in the interest of justice, amendment is allowed.
Issue emergent notice. Order dated 15th March 2022, OS number 363 of 2013 is stayed. Yes. Pass over matter.
Pass over matter, serial number 1, Chandramohan.
Yes, Chandramohan. Yes, sir.
I represent the petitioners in this case.
Yes, sir. Yes, sir.
Petitioners are the defendants in the court below. My lord, the respondents, my lord, filed a suit below claiming for partition against the petitioners and their deceased mother, my lord, and claiming that the father of these petitioners is the father of the second plaintiff and husband of the first plaintiff, my lord.
Yes, sir.
My lord, after completion of the evidence of the plaintiffs, my lord, defendants' evidence also started. Lordship may kindly see the plaintiffs had filed an application earlier, my lord, seeking for issue of summons to the very proposed defendant, my lord.
Yes, sir.
And, my lord, that was rejected on merits, my lord.
Yes.
They never challenged that. Subsequently,
Page number?
my lord,
Page number? Earlier it was rejected.
Earlier application for issue of notice as a witness to the proposed defendant.
Oh, witness is rejected, not the impleading application. Yes, sir.
Not impleading application. Thereafter, my lord, after completion of evidence of the petitioner, my lord, in chief, my lord, they filed this application, my lord, for impleading the proposed defendant.
Yes.
My lord, even
she is also executed to certain documents.
Your lordship will kindly appreciate one aspect, my lord.
Yes.
The proposed defendant, my lord, is the brother of the deceased father of the petitioner.
Correct. Correct.
Except that, my lord, it is nobody's case that the proposed defendant is also having a right in the scheduled properties.
Yes, sir.
The scheduled properties. That scheduled property exclusively belongs to the father of the petitioners, my lord.
Yes.
And my lord.
But that has to be proved only in the trial, actually.
My lord.
That has to be proved only in the trial, actually.
My lord, it is not the case of the plaintiffs, my lord.
Now she is what is saying that her father's right is also, I think, involved in the suit schedule property, because you are the paternal uncle.
No, my lord. I am not the paternal uncle. Your lordship will kindly see the relationship. I will explain the relationship again.
Yes, very good.
The plaintiffs claim as widow and daughter of the deceased Venkatramaya alias Bodappa.
Yes, sir.
They also admit that first defendant was the widow, and the other defendants are the children of Venkatramaya alias Bodappa.
Yes, sir.
That is the case, my lord. They sought for partition against the defendants.
Yes.
Thereafter, my lord.
And she also claims that she is the daughter of. She also claims that she is the daughter of late Venkatramaya.
Yes, my lord. The plaintiffs are claiming as the widow and daughter of late Venkatramaya alias Bodappa. They also admit that we are the widow and children of late Bodappa. That is not, and we have clearly denied the relationship of the plaintiffs with father of the petitioners, my lord. That is one aspect, my lord. And as such, my lord, they claim that the plaintiffs have no right in the properties. My lord, they my lord, to prove their relationship, they wanted to examine the very same proposed defendant, my lord. That was rejected. Now, my lord, after completion of examination chief of DW1, my lord, they have filed this application for
Impeding.
My lord, how he is interested in the property which belongs to the brother, my lord? That is the one question, my lord. That is the important thing, my lord. Because
the proposed defendant is proposed defendant is also a executant in a partition deed produced at Exhibit D24.
Yes, my lord. That does not give him a right in the property. That does not make him a necessary party, my lord.
Yes.
Your lordship will kindly say necessary parties in a suit for partition or who are claiming the scheduled property as they are claiming a share in the scheduled property, and the said defendant is nowhere in the picture. He is not claiming, not interested. But then how he is implicated, my lord?
But he is executant in Exhibit D24.
Yes, my lord. In fact, my lord, your lordship will
Because
kindly
that is a document, that's a partition deed wherein you are also relying upon the same.
I am relying, my lord. In fact, in my
then they should be heard. Then they should be heard, sir.
No. Kindly, your lordship may appreciate. In my written statement itself, this partition deed has been referred.
Yes, correct.
It has been produced along with the written statement.
Yes, sir.
They never bothered.
Yes, sir.
But all, if just because the lordship will kindly say ancestral property, so many other branches will be there.
Yes, sir.
It does not mean that all the branches should be brought in the partition suit, where only one branch is involved. This branch is not involved with the other branch, my lord.
But the proposed defendant claims through the Exhibit D24. That's why the trial court has arrived at the conclusion that he should be heard in the matter.
My lord, is not that's why I'm agreeing, my lord. How can he be, my lord? Because he has no right in the scheduled properties. He is not claiming anything in the scheduled properties.
Yes.
He is entirely belonging to a separate branch.
Yes, sir.
Just because earlier partition they were all parties, that does not make them as a necessary parties. In fact, I am relying on a ruling of Honorable Supreme Court, my lord, in 2005, 6 SCC 733. 2005 6 SCC 733.
733. Yes, sir.
In the para 6, my lord, last portion, my lord.
Yes.
The Honorable Supreme Court says it is now clear that two tests are to be satisfied for determining the question. Who is a necessary party? Tests are there must be a right to some relief against such party in respect of the controversies involved in the proceedings.
Whether it's seeking a relief,
no right
just a minute, just I will ask respondent just for you. Yes, madam. What is the necessity of making him in the as a party? Wife of the second children. What is the necessity of this proposed defendant in favor of defendant? Okay. Not in favor of the plaintiff. Yes, because she is also claims a right, sir. I think their interest will be safeguarded. Yes.
As you will kindly say,
yes,
there is only one scheduled property, my lord.
Maybe,
only
sir.
One scheduled property.
Let it maybe because the partition executed between the proposed defendant and yourself, excluding the plaintiff. Excluding the plaintiff.
Has given the share. Your lordship will, no. Your lordship will kindly appreciate one aspect. The plaintiffs are entirely different people. They are nothing to do with the family. They are not the wife and
that will be considered only in the suit.
Kindly bear with me, my lord.
Yes.
Let me explain this aspect, my lord.
Yes.
And this property which was under that partition deed, my lord, that is the share of father of the petitioners.
Yes, sir. Very well.
That is not belonging to the proposed defendant.
Yes, sir.
That has been given. And how he is a necessary party, my lord, and kindly
Yes.
appreciate this, my lord, this ruling of the Honorable Supreme Court, which says
Yes, very well.
there must be a right to some relief against such
Yes,
party.
correct. But she claims to be the first wife.
No right.
The plaintiff number 1 claims to be the first wife of the so and so late Venkatramaya. Actually,
No, what is the right against the proposed defendant?
that will be proved in the suit.
No, my lord.
That will be
Without
proved
their-
only after
without their
providing opportunity to them. Told.
My lord,
Yes,
kindly
yes.
appreciate not at this stage, my lord.
Yes.
When in the written statement it
Yes.
has been mentioned and it has been produced,
Very well.
and they
Told.
slept over all these days.
Yes.
All these
Yes.
years. Suit is of
This is a
2011.
partition route. Let there be an opportunity for them also. This writ petition is filed by
My lord, their interest is only to
by the defendants.
examine him.
Yes, in OS number 48 of 2008. On the file of the additional civil judge and JMFC Bangarpet, challenging the order dated 10th June 2019, allowing the IA number 20, filed under order 1 rule 10 of CPC. The relevant facts for the adjudication of this petition are that the plaintiff has filed a suit seeking partition and separate possession in respect of the suit schedule property. Claims to be the first wife of late Venkatramaya. The defendant number 1 claims to be the second wife of late Venkatramaya, and remaining defendants are the children of the defendant number 1. During the pendency of the suit, the plaintiff has filed application under order 1 rule 10 of CPC to implead the proposed defendant as the additional defendant in the suit, and the said application was resisted by the defendants. The trial court, after considering the material and record by impugned order dated 10/6/2009, allowed the IA number 20 filed by the plaintiff, and being agreed by the same, the defendants have preferred this petition. Sri Chandramohan, Lana counsel appearing for the petitioner, contended that the trial court has committed an error in allowing the application, impleading the proposed defendant as the said additional defendant is not belong to the branch of the plaintiff and the defendants in the suit, and is a stranger to the relief sought for in the plaint, and therefore the trial court has committed an error in allowing the IA number 20.
My lord, kindly, my lord, we are disputing the relationship of the plaintiffs.
If further submitted that the defendants have disputed the relationship of the plaintiff, and therefore allowing the application filed with trial court requires to be interfered in this petition, as the proposed defendant is not a necessary, is neither a proper nor a necessary party to the proceedings. Per contra, Madam so and so, and a counsel appearing for the plaintiffs. You are appearing plaintiffs. Plaintiffs contended that the proposed defendant is the paternal uncle of the plaintiff number 2, and the plaintiff number 1 is the first wife of the late Venkatramaya, and therefore, as per the partition deed which has been marked as Exhibit D24, allotting the properties in favor of the defendants with respect to the suit properties which is belong to the father of the plaintiff number 2, and therefore the said partition deed within bracket exhibit D24 has to be considered in the suit, and accordingly the proposed defendant is required to be made as the proposed as an additional defendant for adjudicating the suit. Accordingly, she sought for dismissal of the writ petition. In the light of the submission made by the Lana Council appearing for the parties, it is not in dispute that the relief sought for by the plaintiff is with regard to relief sought for by the plaintiff seeking relief of the partition separate possession in respect of the associated properties, claims to be the first wife of late Venkatramaya, and the defendant number 1 claims to be the second wife of the late Venkatramaya. And though the defendants have disputed the relationship between in the suit, and same has to be proved in the suit by full-fledged evidence. The proposed defendant is claims to be the party to the exhibit D24, dash partition deed effected between the proposed defendant and the defendant's hearing, excluding the plaintiffs, and in that way of the matter to resolve the dispute effectively in the suit, the proposed defendant is a necessary party to the proceedings. Accordingly, the trial court is justified in allowing the application filed by the plaintiff. Accordingly, I do not find any merit in the writ petition. Accordingly, same is dismissed as devoid of merits.
So, after matter,
Password Madila 213.
Serial number 32.
32, yes, sir. Yes, sir.
Other matter.
Nothing. Please, sir.
The respondent has filed a suit. Respondent number 1
yes.
has filed a suit for partition and separate possession in respect of 2 items of property, house property.
Correct.
The contention of the respondent number 1 is
yes.
that he is a biological son of Lingaya and Prema.
Yes, sir.
Lingaya expired in a road traffic accident.
Yes, sir.
And his employment has been given to Srimati Prema under compassionate rule. Thereafter, Prema also expired in the year 2016.
Yes.
Claiming as Dalai, if he was working as a Dalai,
yes, yes,
respondent number 3.
Yes.
Claiming the property of both Lingaya and Prema couple.
Yes.
Not this respondent number 1 as well too.
Yes.
The petitioner contention is the respondent number 1 is not biological son of Lingaya. Lordship may kindly appreciate.
Yes.
Let me complete, sir.
My lord, the notice has not been served on the respondent number 1.
Yes, yes, sir.
Notice was not served on the respondent number 1, my lord.
Just a minute. You are representing the respondent number 1. You have not received the copy of the petition. Sir, copy.
To the address furnished by the plaintiff is the constator.
Okay, let will argue. You argue the matter. What is the error committed by the trial court?
Paid by the defendant for DNA examinations of the plaintiff with defendant number 1
yes,
has been rejected.
Correct.
Lord, that is on 3 grounds.
Yes.
One, Lord, the prayer is not proper. And the second one is the documents produced by the defendant, that is the school record and judgment and decree passed in MVC case, in which the plaintiff also shown as legal heir of Lingaya.
Yes.
And the third one is section 112 of Indian Evidence Act.
Yes.
Now, on these 3 grounds, the prayer court has dismissed the idea.
Yes.
My respectful submission is, Lord, may kindly appreciate annexure.
Yes, sir.
Annexure H.
Yes. What's the error committed by the trial court?
Lord, 3 grounds, Lord.
Yes.
The trial court has not appreciated provision 112 of Evidence Act properly.
Yes, sir.
That provision has been misread.
Yes.
May I argue on that point?
Yes. Yes.
Lordship may kindly appreciate.
Yes.
Section 112 says,
Sorry. Evidence, sir.
birth during marriage, conclusive proof of legitimacy.
Yes.
The fact that any person was born during the continuation of valid marriage between his mother and any man, or within 280 days after its dissolution,
yes,
the mother remaining unmarried shall be conclusive proof of that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten.
Yes.
This provision applies only when there is a dispute between the couple regarding birth of children.
Yes. Yes. Next.
Not here, the defendant number 1 is disputing, and on that point, I have authority passed with the coordinate of the sample court.
Yes, sir.
Which my lord, I want to read only one paragraph, paragraph number 40,
Paragraph?
last page.
Paragraph 40.
40, in last page,
Yes, sir.
short paragraph. The presumption available under section 112 of Evidence Act would come into play where the husband questions the paternity of son or daughter, as the case may be, by contending that he had no access to the wife. A presumption of a fact depends upon satisfaction of certain circumstances. Those circumstances would ultimately lead to the fact sought to be presumed. This is what section 112
Yes.
provides for by way of presumption.
Yes, sir.
Such section would be inapplicable to facts on hand. Not here, the dispute, this fact is disputed by the petitioner here.
Yes.
That is the defendant number 1. Under such circumstance,
Yes.
this presumption under 112 has no application to the present fact of the case.
Yes, correct.
Then, Lordship may kindly appreciate annexure F,
Yes.
page number 144.
Yes. 140?
144.
Yes.
Now, it is my contention
Yes.
that the plaintiff is son of Savitri and Srikante Gowda,
Yes.
not biological son of
Yes.
Lingaya and Prema couple.
Yes. Birth certificate.
Yes, my lord. Lordship may kindly appreciate name of mother Savitri in the middle portion of 144. And on the next slide, Srikante Gowda.
Yes.
When this document was confronted, the plaintiff PW1 answered evasively.
Yes.
The Lordship may kindly appreciate the next document 145, page number 145.
Yes.
Originally, Murthy, son of Srikante Gowda.
Yes. Yes.
Now, this printout was taken on 2nd September 2013. When this Aadhaar number was confronted along with this document, he answers evasively in cross-examination. Then, Lordship may kindly appreciate Page number 139.
139.
139.
Yes.
Electoral list.
Yes.
ಇದರಲ್ಲಿ D3A.
Serial number?
L Murthy.
Serial number?
638.
638.
Murthy L. ತಂದೆ ಹೆಸರು ಶ್ರೀಕಂಠೇಗೌಡ.
Yes.
637 ಸಾವಿತ್ರಮ್ಮ ಗಂಡನ ಹೆಸರು ಶ್ರೀಕಂಠೇಗೌಡ.
Yes, sir.
ಶ್ರೀಕಂಠೇಗೌಡ is no more.
Yes.
Not all these documents.
That's
when it was confronted to him during cross-examination,
that's a big problem. Yes, sir.
May I read those questions, Lord?
Yes, just I got it. Yes. Next.
Lord, under this background, the documents produced by the PW1, that is the SSLC certificate, and as a legal aid, he also one of the claimant in the MEC case.
Yes.
There is conflict between these two documents.
Yes.
Not produced by the plaintiff and also by the defendant.
Yes.
Not Savitri.
Yes.
Not is none other than sister of Prem. He has come to my house. He has studied here, and by that time those documents have been come into picture.
Yes.
And he has also made as a claimant in MEC petition. That itself does not mean that he is also entitled for partition. But my lord,
you are also claimant in the MEC?
Yes, my lord. I am also claimant. There is no dispute with regard to my paternity. I am the only daughter to Lingaya and Prema couple.
Yes.
By taking undue advantage of the situation, this respondent number 1 is claiming a son, and he has also produced.
So while getting compensation, this was not the problem.
SSLC school records allu ondastige ಇನ್ನೊಂದೇ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ತೋರಿಸ್ತೀನಿ.
Yes.
Exhibit D20 131 page number 131.
Yes.
ಇದರಲ್ಲಿ ಡೌನ್ಲೋಡ್ ಆಗಿರೋ ಡೇಟ್ ನೋಡಿ, ಇದು ಆಧಾರ್ ಕಾರ್ಡ್.
Yes.
ಅದನ್ನ ಚೇಂಜ್ ಮಾಡಿರೋ ಡೇಟ್ ಇದೆ 2016.
So yes.
ಪ್ರೀವಿಯಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಹಾಜರು ಮಾಡಿರೋದು 2013 ಅದು. ಅದರಲ್ಲಿ ತಂದೆ ಹೆಸರು ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಇಲ್ಲಿ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ಹಾಜರು ಮಾಡಿದ್ದಾರೆ.
Yes.
Not based on these documents.
So you are also claimant number 2 in MBC.
Yes, ma'am.
He is also claimant number 3.
Yes.
See, while so you allowed.
Not I disputed those documents in cross-examination.
Yes.
Not my contention is simply because he has arrived as a claimant, it does not mean that he is biological son of Prema and Lingaya couple.
Yes. But in the caste statutes, if son of first petitioner Prema, in the MVC document it says so.
ಹೌದು, based on that not the trial court has dismissed my IA.
Correct.
No, not the trial court. It is referred for DNA test. Scientifically, the truth will come out.
Yes, sir.
And my defense also will struck out.
Yes.
And such a if contrary report has come.
Yes. Any case law that you have?
Yes, no, I referred.
Yes, sir. That's the one.
Is not applicable to the present case.
Yes, sir. It's not a case for interference. Writ petition dismissed. Reasons to follow. Yes. Reasons to follow.
Serial number 41, Sri Vaidya Narayan Sharma.
What is the petition?
The matter regarding regarding that application I filed. Under I filed an application.
No objection for adjournment. At the request made by the Lana Council appearing for the respondent number 1, list after summer vacation. Yes.
Serial number 42, Sir Ananta Krishnamurthy. Serial number 42.
Yes, sir. HR Ananta Krishnamurthy.
Petition on this case, madam.
Yes, sir.
Madam, sale notice annexed G is under challenge, madam.
Just a minute. That's it. Chamber.
Annexed G
Annexure G.
G, my lord, Annexure G, page number
Reasons to file.
29.
That earlier.
Page number 29.
20?
9, my lord.
29, 1 minute, sir.
Yes, sir. Page number
Yes.
29.
Annexure G, yes, sir.
G. Sale at spot 12/6/2019 and sale at court 12/7/2019.
Yes.
This is the sale notice, my lord. Then you will also take the amount, my lord. 13,000.
Where are you reading, sir? Where are you? Page?
29.
29 only. Yes.
Yes, sir. Only amount fix ಮಾಡೋದು sale proclamation sale amount 15,13,000. Mail conduct 14 indicate that is there in the got it your lordship?
No, sir.
Annexure
Yes.
G, Annexure G, my lord.
I'll go to 15,13,000.
Yes, madam. Yes, madam. Then you will lordship turn to the order sheet, madam. Order sheet Annexure D.
Annexure D.
D, madam.
Yes, sir.
Annexure D, madam. Page number 17.
17, yes, sir.
35/2019, madam.
35/2019, yes, sir.
Yes, sir. Counsel for JDR got advanced the case and filed an application on 151 of the CPC to recall the sale warrant and also produce a demand of for 2 lakhs. It is in the name of the DHR. The counsel for DHR refused to receive the amount, demand draft, and pays time to file objection. Hence, office is directed to keep the demand of safe custody.
Correct.
And the objection to IA call on 12/7/2019, madam.
Yes.
This is the order of the court, madam.
Yes, sir.
Madam, your lordship, the sale proclamation spot is 12/6. Though
Yes.
the matter was posted for objection of the application filed by the
JDR. Yes.
The sale at spot is fixed on 12/6/2019.
12/6.
Yes, madam. As per Annexure G, madam. I have already
Annexure
pointed
G. Yes.
Yes. 12/6/2000 spot. Court sale at 12/7/2019.
12/6/2019. 2019.
12/7/2019. Though the matter was posted for objection to the IA filed by the JDR.
Yes.
In recalling the sale proclamation, but this objection was not put. Then you will also turn to the Annexure G, Annexure E, madam.
Yes. Let an opportunity be given to you also.
Yes, yes. Then an Annexure E may kindly be taken regarding the value of the property. E, my lord.
Annexure?
Page number 9.
E.
Page number 19.
Page number?
Page number 19, my lord. Annexure E.
19 is the objection.
Yes, madam.
It's following objection to the sale notice.
Sale notice, madam.
Yes, sir.
May I read it, madam?
Yes. Which relevant para, sir? Relevant para?
I will. Para 2 give it. This land is situated nearby Biru, Chennagiri.
So you wanted to purchase it for 2 crores and odd?
Yes, madam. But actually, no. Value of the property is 22 crores, 22 lakhs, 15,000. But sale proclamation indicates 15,000 and odd. That's why I part of 15,000, 15 lakhs, 13,000. The value of the property, even per amount, you will also turn to the valuer at page number F, Annexure F, page number 25, madam.
Annexure F.
F, the valuer, competent engineer valued the property.
Yes. According to him, what is the value?
Annexure F, my lord.
Yes, sir. What is the value?
Value, my lord, I'll point out. You will also turn to 2 crores 50 lakhs, sir. 250 lakhs at page number 28, my lord.
28.
28.
250 lakhs.
Yes, my lord. Meanwhile, my lord, certain development has taken place, my lord. Of course, the impleading applicant has filed a produced.
Yes, just a minute. Yes, what is? When the application is filed, and objection was called for from the DHR as per order sheet 35/2019. Thereafter, trial court would have given an opportunity for the JDR.
That's what I want to make the opinion, because they have not produced the entire order sheet. Because after filing this petition, subsequent developments, there are so many subsequent developments.
Yes.
In fact, petition itself will become infectious.
Why?
That is not the case.
On 24/7/2019, the sale warrant and proclamation has been issued.
Whether stay has been granted in this petition?
Yes, subsequently stay has been granted. Stay has been granted, my lord.
One minute. Yes, sir.
Subsequent certain development has taken place before the trial court itself. Matter was may refer to the mediation, and there JDR and DHR entered into compromise. They has received the amount. Meanwhile, according to my friend contention is that I have purchased the property in a public sale notice. But of course, sale it was.
Have you deposited 5 lakhs rupees before the trial court also, sir? As per the order passed by this court.
ಅಲ್ಲ ಅದಕ್ಕೆ ನಾವು ಮಾಡಿದ 5 ಲಕ್ಷ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಮಾಡಿದ ದಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮೇಲೆ.
Yes, sir.
ಅದು ಮಾಡಿದ್ದೀವಿ. ಅದಕ್ಕೆ ಇವರು ನಾವು ಆಲ್ರೆಡಿ ಇವರು
stay was subject to payment. I think it has been deposited.
That we made.
Stay was granted on 4/6/2020. By that time, the sale certificate was already issued. Was already ordered to be issued in my favor.
But the property worth more. What is the sale certificate? What is the amount specified there?
21,50,000.
Property was 2%.
They say they have got valuation report from private engineer. The executing court has conducted sale as per the valuation report submitted by the jurisdiction sub-registrar.
Yes. What is the evaluation by the sub-registrar?
17,80,000.
Where is that?
In my statement of objections, I have produced the entire certificate copy of the entire order sheet of certificate copy.
Yes.
That is order dated 12/7/2019.
12/7.
In page number 6, please. Order date.
12/7. Page number, sir. 6.
In Annexure R1.
Annexure R1.
Page number. DHR present. No representation by JDR.
6, sir.
3, please.
In statement of objections.
I have produced Annexure R1 only my statement of objection.
Correct.
Which is the entire order sheet.
Yes, correct.
Certificate copy of the entire order sheet.
Yes. There is a relevant page.
Relevant page, it is in 6 only. Page number 6.
6 is verifying affidavit.
No, it starts from Annexure R1. Annexure R1, I have one.
Annexure R1 is the.
Separately.
Yes.
In page number 6. Order dated 12/7/2019.
12/7.
Please.
Just 12/7.
2019. Here,
That is page number 11. Yes, sir.
DHR present. No representation by JDR.
12/7.
Please.
That is a sale warrant in respect of a petition scheduled property is duly executed.
Then
12/7.
yes, in page number 7, today self proceedings held before the court premises in public action. 3 persons, namely Gopalappa, Benakappa, and M. Chidananda, are participated in the public action.
That is 12/7. Yes.
Please. One M. Chidananda, who is the highest bidder of the petition scheduled property, successive bidder. As per the valuation certificate issued to the publisher, rupees 3,50,000 is fixed per 1 acre land situated at the village where the petition scheduled properties are also situated.
It's agricultural land?
Yes.
Is it agriculture? Yes.
As per the valuation fixed by the
So
publisher.
17 lakhs.
The total 70,85,000. The highest bidder intended to purchase the petition scheduled property for a sum of rupees 21,15,000. So the bid amount is more than the market value fixed by the
Not
publisher.
market value, guidance value.
The guidance for
Market value will be different.
the sub-register has issued certificate on the SRI. Then hence the bid amount is accepted.
Yes.
Yes. After this, on 2/7/2019, after the 12/7 proceedings,
12/7.
on 15/7/2019, the JDR, he filed an application one of the to set aside the sale of property, saying that he will make entire payment ticket. Then it will on
And pay the entire amount is given. Yes, sir. 15/7 he has paid the entire amount.
I have a copy.
Yes, sir. Yes, sir.
On 17/7/2019, the JDR filed one more application under Article 21/83 clause 1 CPC to postpone the sale. Then on 18/10/2019, IA number 4, that is under Article 21/92, 1 CPC came to be dismissed.
Yes.
Then IA 5 under Article 21/83, subclause 1 CPC to postpone the sale has been considered by the executing court this last.
Yes.
And 2 months time was granted to make the payment. Then, however, he did not make payment till 2/1/2020.
2/1?
2/1/2020.
Yes.
Then on 2/1/2020, the sale held on 12/7/2019.
Yes.
Confirmed and ordered to issue sale certificate in my.
Yes. Then, sir?
Then on 8/2/2020, the JDR filed one more application under section 114 of CPC for review. Then on 4/6/2020,
4/6/2020. 2020. This is up to 13/1. Order sheet is up to 31/1/20.
4/6/2020, I am not taking the position on the order sheet. On 4/6/2020, granted in the market. That is after.
So by the time the sales certificate was issued.
Sales confirmation was already made in my.
Okay, sir. Then you have to challenge that, sir.
Yes, so that is what.
Regarding the
Yes.
I am reviewing any judgment of the Honorable Supreme Court.
By the time.
Regarding the value, my lord.
They did not make me as party people. So they were aware of.
So now, what you challenge now?
Yes.
In the writ petition, just go to the impugned order.
Annexure G, my lord.
Annexure G, order dated 27/4/2019.
Yeah.
Much water has flown afterwards.
No. Subsequently, my lord.
Yes, much.
This writ petition was pending before the Honorable Court, my lord.
By the time, many time, I think auction was conducted, sales certificate was issued.
No, subsequently, my lord.
That you have to challenge.
The permanent hardship returned to the. Like, Amel in development, I guess, sir.
No, for the further proceedings, I think the 27/4/2019 order has become redundant now.
No. The thing is, my lord, for a moment of hardship, or subsequently the trial court itself has remanded the matter to the mediation.
Yes, afterwards, take an order on IA number 4 and the order on IA number 6, C5 to postpone the sale of property which came to be dismissed. Then 2/1/2020 order. I think you have to file a comprehensive petition if you want. Otherwise, 27/4/2019 has become now sale proclamation. Already it has become.
Sale certificate is not issued, my lord. In addition to that, my lord, regarding the.
Sir, what is challenge is order of proclamation.
Yes, my lord. Yes.
Now it is sold.
No,
once it is sold.
Sale certificate is not yet issued. Not yet issued to the.
That is not the subject matter. That is not the subject matter in the writ petition.
No.
Subject matter is only order of proclamation.
Proclamation.
Then,
may make a next Monday, so that further development I will have to furnish to you.
Yes,
because the very court has remanded sent to the mediation. Ali matte degree GDR decree set as compromise.
No, sir. I think writ petition has become infructuous. Insofar as the order dated 27.
Till Monday, so that I can produce the.
No. I think because he has produced the 2019 matter.
No, that is true, my lord.
You can challenge the remaining orders if you are so advised.
No, because the sale certificate is still not issued.
Maybe true, sir, but a sale has been effected. I think so. Sale certificate is also issued.
No, not yet issued. Not yet issued.
By that time,
ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಸರ್, ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಅದು.
Sale held on 12/7 so and so wherein so
Sale
and so
certificate ಕೊಟ್ಟಿಲ್ಲ.
purchased the property.
Sale certificate is not issued.
Issue sale certificate in the name of purchaser of the property.
Issue ಆಗಿಲ್ಲ.
All on 13/2. That is
Issue ಆಗಿಲ್ಲ. Meanwhile, refer to the mediation. Their judgment letter and decree order settle the matter.
you can challenge that. You can
particular order.
No, what is challenge is only order of proclamation, sir. That cannot be done.
Because subsequent, because he has also produced subsequent
You
development.
can challenge. So,
Because my lord, he has also produced subsequent development.
this writ petition is filed by.
But after all this, there is a mediation order is there.
Very
They
well.
have, no, they have settled the dispute between the DHR and the JDR.
Yes.
Produce what he said. So
You can challenge the subsequent orders. So you can challenge.
No, that order, no, because my lord, the JDR and decree order settle the matter. ಇವರಿಗೆ ಇದು ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ. At the point of time, for a moment you will have to take till next.
That could be done, sir. But the order of proclamation is there. Third, you can challenge. Otherwise you can withdraw and file a fresh petition.
No,
Otherwise, I will say I think order of proclamation is not maintainable because much water has flown now.
No, but proclamation, my lord, because the subsequent development,
Yes,
that order,
that you can challenge. That you can challenge.
Compromise, ಇವ್ರು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ, ಯಾಕಂದ್ರೆ ಮೇನ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ. ಅದು that order have to produce. That the
In this order, yes, in this petition,
till Friday, my lord.
In this writ petition, the petitioner has challenged the order of proclamation dated 27/4/2019. In execution petition number 29 of 2018 on the file of the senior civil judge and JMLC Kadur. Full stop. Heard the Learned Counsel appearing for the parties. Learned Counsel appearing for the respondent, brought to the notice of the court with regard to the orders passed by this passed by the executing court pursuant to the order of proclamation made on 27/4/2019, where the order sheet produced by the respondent would indicate that the as per the order sheet at 12/7/2019, the sale proceedings was held before the court premises in public auction and pursuant to the valuation certificate issued by the jurisdictional sub-registrar, fixing the sale as rupees 3,50,000 per acre in respect of the land situated in Dogihalli village, Birur Hobli, Kadur Taluk, and pursuant to the same, the highest bidder / you are the highest bidder, respond number 2, as agreed as participated in the auction and agreed to purchase this scheduled property for rupees 21,15,000.
IA number 5 order ಒಂದು ಸ್ವಲ್ಪ ನೋಡ್ಬಿಡ್ಬೇಕು ಸರ್.
Yes, 51,000. And accordingly is deposited. Yes, and accordingly deposited the 25% of the sale amount before the court. Full stop.
One submission mother.
Yes, one nimsham. Just order sheet I will compare.
ಅದನ್ನ IA5 order ನೋಡ್ಬೇಕು. IA5 order.
Yes, pursuant to the same.
22.
Yes, just 1 minute, sir. Pursuant to the same, the respondent number 2 herein, has paid 2 demand drafts for sum of rupees 5,30,000 before the court below, and accordingly the matter was adjourned for payment of remaining sale consideration amount on 17/7/2019. However, the second respondent 2 purchaser of the property has paid the remaining sale consideration of rupees 15,85,000 through DD drawn on Vijay Bank, Berur branch before the court on 15/7/2019, and accordingly thereafter the case was posted on various dates, and in the meanwhile the JDR has filed IA number 4 under Order 21 Rule 92 of CPC, seeking and CPC, and the said application came to be dismissed by the trial court on 18/10/2019. Full stop. Again the JDR has filed application under Order 21 Rule 83 Class 1 of CPC to postpone the sale of the property. However, by the set time, the auction proceedings were concluded. Auction.
2 months time was granted to make payment.
It's a to postpone the sale of property to enable the JDR to raise the amount to discharge the decretal amount. In that way of the matter, taking into the trial court, granted 2 months time to the JDR to pay the entire decretal amount with accrued interest as per law by order dated 18/10/2019 on order on IA number 5. Full stop. Thereafter, the case was taken up on several dates, and on 2/1/2020, the trial court has observed that the JDR number 1 is not interested to pay the amount to the purchaser of the property after providing opportunity, and accordingly has ordered for issue of sale certificate in favor of the purchaser of the property / respondent number 2 herein by order dated 2/1/2020. Taking into consideration the various orders passed by the trial court, I am of the view that the writ petition is become infructuous and cannot be considered at this juncture. However, the learned counsel appealing for the petitioner seeking liberty to challenge the issuance of the order passed by the executing court relating to the sale certificate and
Supreme Court judgment regarding rates
and
prices.
However, reserving such liberty to the petitioner, writ petition is dismissed. Yes, reserving such liberty.
Dismissed. Not dismissed. That will also
ನೀವು ಹೇಳೋದು ನಾವು ಹೇಳೋದು dismissed.
ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್
43. Yes, sir. Yes.
Supreme Court judgment on refer ಮಾಡ್ಬಿಡಿ.
No, sir. That cannot be.
2017 regarding the value of the property.
Anyway, opportunity has been given to you, sir. 2 months that you have not done. Yes, sir. Plaintiffs? Plaintiff for writ petitions. Yes, what your challenge here?
Challenge is the rejection of the amendment application filed by the petitioner seeking certain corrections and also subsequent events during the pending suit.
So amendment is corrections.
Yes, ma'am. Correction and subsequent events during the pending suit.
Where is the impugned order?
Impugned order at the impugned number.
Annexure D.
Annexure D.
Yes, sir. What you want to suit for? Suit for? Suit for partition.
Suit for partition. Annexure B.
Annexure B is the
amendments are
yes.
In line number 3 after word sister add let Nama. In lines 3 and 4 relate to words of dependent number 4.
Yes.
Are brothers and sisters inside in place of dependent number 3 and 4 are
Yes.
sisters.
Yes. Next.
In para 3 and para 5 third line in the word dependent to add as being his son.
So you wanted to substitute the plaintiff itself?
Yes, sir.
Huh.
This some
You wanted to substitute the plaintiff? So many amendments.
ಡಿಕ್ಟೇಷನ್ ಹೇಳುವಾಗ ಏನಾಗೈತಿದೆ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ತಂದೆ ಸಿಸ್ಟರ್ ಅನ್ನೋದು ಮಗಳಾಗೈತೆ ಮಗಳಾಗಿರೋ ಸಿಸ್ಟರ್
Because it's so nine amendments you wanted to make.
Yes, ma'am.
Yes, it's more than the plaintiff. More than the pages in the plaintiff. More than the pages in the plaintiff.
ಅದೇನಾಗಿದೆ ರಿಲೇಶನ್ಶಿಪ್ ಸ್ವಲ್ಪ ತಪ್ಪಾಗಿ ಹೇಳ್ಬಿಟ್ಟಿದೆ ಅದಕ್ಕೋಸ್ಕರ ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ರಿಕ್ವೈರ್ಸ್ ಅದರ್ವೈಸ್ ಮಾಡಿದೆ ಅವರು ದಿ ರನ್ ಜಡ್ಜ್ ಆಲ್ಸೋ ವೆರ್ ಡಿಫಿಕಲ್ಟ್ ಇನ್ ಪಾಸಿಂಗ್ ದಿ ಆರ್ಡರ್ ಸಿನ್ಸ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ದಿ ಫ್ಯಾಮಿಲಿ ಪರ್ಸನ್ಸ್ ಇಟ್ಸೆಲ್ಫ್ ಇಸ್ wrongly mentioned below, it is absolutely required for the elicitors.
The fourth amendment application filed, they have not come completion. Now the amendment which they have sought,
This is the fourth amendment you sought.
Fourth amendment. The fourth amendment they have said.
Where it is stated?
Earlier is the third amendment.
Yes, sir.
And will be permitted to do this. The third amendment. It was recently on.
After this.
After this application, within 6 months, there was another amendment application. Kindly see the order.
Yes, sir.
Certificate copy.
I do agree, Malad. Since Malad,
They will not come with this. See, this amendment, they were supposed to annex this amendment application.
Earlier also you filed, I think.
5 years is been amended.
It's a 2011 matter.
Malad, the amendment is not a whole case itself will become
An opportunity has been given to you. That's what the learned judge has pointed out in his findings.
You will actually may impose certain conditions, Malad.
No conditions.
Because of the matter within 2 months,
No,
I will cooperate with you every day, Malad.
Not necessary. Not necessary.
Otherwise, Malad, subsequent events, Malad, that also, Malad, during the pendency of the case,
This is the third amendment application.
This is the fourth amendment. That is the third amendment.
It is third.
Already allowed.
Not case for.
Otherwise, relationship of the parties, I will not be in a position to convince the judge in any other manner. It will entirely,
Now it will be done.
Please, Malad.
Now it will be done after dismissal. Yes.
Malad,
Writ petition
dismiss it,
dismissed.
Malad.
Sir, writ petition is dismissed. Reasons to follow.
Malad.
Third, fourth defendant. That cannot be done. There are a number of judgments.
Typographical errors, Malad. And moreover, Malad, during the pendency of the case, Malad,
Yes, sir.
the property was,
Not a case for interference. Yes.
Malad, otherwise, Malad, it will affect whole of the case, Malad.
Hold on.
Malad,
Yes.
imposing some price, Malad.
Yes. Rangaramoro, I think your name will be shown. It is dictated. Yes. And I have incorporated. It will be listed next week. In Monday and Tuesday we have a number of matters. I think the Wednesday. Wednesday could it. Yes. We have shown. We have. Yes. 2000. Serial number? You want adjournment? You are seeking an adjournment now. Are you ready? Then it will be taken up in that.
What officer, ma'am?
ಹೇಳಿ ಕೋಟಲ್ ವಾಯ್ಸ್ ಆಡಿಬಲ್ ಇದೆಯಾ?
ಹಾ ಮೇಡಮ್ ಆಡಿಬಲ್ ಇದೆ.
ಓಕೆ.
Court officer, ma'am.
ಏನ್ ಮೇಡಮ್ ಹೇಳಿ. ಬರ್ತಿದ್ದಾರ ಜೊತೆ?
Serial number 55.
After kind permission, serial number 53, madam.
53.
53, I was filed wakalat and we have responded to 102 on 22/12/2021. But my name has not been shown today.
You are for the?
I am for respondent, only 2 respondents.
Respondent 1 and 2.
1 and 2.
I wish to make one submission, madam. The improved order relates to interim sale of macro crops. Since the nature of the crops is perishable in nature and the harvest months of May and June are
It will be taken up in the event.
kindly take up the matter next week, madam.
Next week.
After vacation, it would be too late, madam.
Family member.
Yes.
No, madam.
No, let us wait.
My name may be shown in the
So and so told.
CM Venkat Reddy.
Then a counsel Shri CM Venkat Reddy submitted that he has entered appearance on behalf of the respondent number 1 and 2. Registry is directed to print the name of Shri so and so appearing on behalf of the respondent number 1 and 2. List next week.
Next week, madam.
List next week.
I object.
Pronouncement of auditor. No, list next week. Let us.
Serial number 59, Sri Vinod Prasad.
Appear for the petitioner, my lord.
Vinod Prasad. Serial number 59.
59. Writ petition is dismissed. Yes.
Serial number 60, Sri Prakash Arvi.
They appear for the petition.
Yes. Writ petitions are allowed. Order dated 26 March 2021 pass in OS number 519 of 16, 518 of 16, 529 of 16, 520 of 16, 524 of 16, so and so on the file of the Principal City Civil Court is set aside.
Serial number 61.
Waiting for the petitioner, madam.
Yes. Respondent. Writ petition is dismissed.
Matter pertains to Kalburgi bench. Serial number 1, list number 2, Sri Raja Venkata Nayak.
Appear for the respondent, my lord.
Yes, sir. Writ petition is dismissed. Yes.
Obliged.
Yes. Yes, ma'am. End of the list here.
230 matter, moot matter. Serial number 1, Sri Dinesh Raman. This is because I have filed the
Well, accepting the submission made by the Rana Council applying for the petitioner, writ petition is dismissed as withdrawn. 32? 5? 1 minute. Annexure G is challenged. Just. Which order that you are challenging? Which order that you are challenging? Annexure G. Annexure G is challenged. E, no? Go to prayer. 29:11.
Report submitted by the board commissioner is hereby accepted. Hereby directed the board site for speedy disposal of application since the matter
Yes,
is
ma'am.
related to the
Next.
proposal for the administration.
Idal, just by mistake. Next matter. Annexure G, 1 minute. Reserving liberty to the petitioner to challenge impugned order in appeal if so advised. Yes, petition is dismissed as withdrawn. Yes. Passed over.
Passed over matter, serial number 4.
Yes.
This is the defendant's requisition.
Yes, sir.
Again, the concurrent findings of the injunction of
Just a moment. Yes.
the annexure C page 46 is the claim.
Yes. Suit for?
Suit for damage.
Fair enough. Yes.
And kindly look at the entity of this, because I have disputed the very existence and the entity of the plaintiff itself in the suit by raising a maintenance, etc. Kindly look at this, Heranje, late Abraham Hegde Memorial Public Library, Heranje represented by its president, Dinakar Shetty, so and so, this is the, he representing, calling himself as a president of that entity which is no more in existence, to which I have produced voluminous documents, which is the subject matter.
Yes.
Entity of the plaintiff itself I have disputed.
Very good.
No, kindly see page 55 is the schedule.
52nd. 55 is the schedule.
55, prayer 50.
Yes.
Prayer 50.
Yes.
For perpetual injunction restraining the defendants, their men, workers, agents, and all persons claiming to or under them from trespassing into and forcibly taking the possession of the area, can you note that word? Area in which the Heranje late Abraham Hegde Memorial Public Library Heranje building is situated, or from in any way interfering with the day-to-day affairs of the library, and not to interfere with the peaceful possession and enjoyment of the area with the plaintiff building is situated by the plaintiff. No, the plaintiff is not claiming the title of the property. Well, the case of the plaintiff is that there was in the land belongs to the defendants and their forefathers.
Yes.
Well, the school building was permitted to be constructed, and later the school building came to be closed. And with the well wishes of the village, this committee is constituted, stating that that school has been converted into a library, to which the plaintiff himself is calling himself as a president of that library committee. He came into possession of that building. Then we are making an attempt to dispose him alone. He filed this suit for injunction.
Yes.
With regard to this portion is concerned. Now, you must kindly turn to the schedule of the property.
Yes.
Page 51.
Yes.
Immovable property, so and so, school building
So
inventory.
now as on today, according to the plaintiff government, he is in possession of the property.
No, he says that, but so far as the possession and iota of evidence is concerned, there is absolute not, there is no material available. Now, you know, kindly see.
Yes.
The school building in which the Raghuram Hegde Memorial is situated, so and so, measuring 1 acre 30.83 cents, which is a description of the property shown in the plan.
Yes.
Now, with regard to which, now the injunction application came to be decided by the trial court.
Yes.
Kindly see the injunction order, is annexure B, page 37.
Yes.
Now, you know, kindly come to for a moment,
Irrespective of the challenge that you made, see, with regard to the his claiming his ownership insofar as social property is concerned, the perusal of the environments made in the plaint would indicate that he is in possession of the property.
Well, not in the exact manner. Injunction is granted, it's my property, I have purchased my husband's property.
Yes.
Well, I purchased in the year 1975.
Yes.
How the injunction can be granted the entire 1 acre of the land?
Have you found
His government himself is he is in possession. He is in possession enjoyment of the building.
But in the written statement,
yes,
have you claimed counterclaim at least?
Well, not counterclaim, I have disputed it, because I produced the title documents, I have produced the revenue records, kindly look at the annexure,
That will be considered by trial court in the.
Trial court cannot grant an injunction under detrimental by interest of the enjoyment of the entire extent of property.
Yes.
It is the plaintiff's clear-cut case is that he is in occupation of the building, which is got to which it should come around 2 to 5 cents something like.
Very well.
Normal, whether the trial court is justified the granting the entire injunction order to the entire extent of 1 acre 38 cubic of land,
yes,
cents of land. Which is the valid ground, which is kindly look at the interim order, the injunction order, annexure B.
Yes.
Now, you may kindly turn to the reasons onwards, page number 40.
Only restraining you from interfering with the library.
Well, the injunction is granted, kindly look at below. IA2 filed by the plaintiff under so and so is hereby allowed.
Yes.
The schedule is filed with regard to the entire 1 acre and all.
Please read it. Next.
The defendants, their men, workers, agents, and all persons claiming to or under them are hereby restrained from trespassing into and forcibly taking the possession of the area in which the
area in which the library is situated. Where the library is situated.
Well, the extent of now is shown for the injunction, the schedule it has been granted for an entire 1 acre.
Yes, sir.
Well, this is the discretion which I wanted to have the intelligence from the appellate court.
Yes, sir.
Now, you know, kindly see the reasons assigned by
whether you got the interim order in this.
I got the interim order of the stay of the order. Well, kindly look at this paragraph number 12.
In this repetition?
Yes, sir, in this repetition, that's the interim order.
When it was granted?
But
1 minute.
Initially, notice was issued not. I filed Wakalat. My Wakalat was not put up to the file.
No, my lord, by virtue of this interim order, I have been prevented from enjoying my own property, which is not as well in his possession. I have produced the artificial revenue records. Nothing has been considered.
Yes, anyway, the 2/7/2021, this court has granted
injunction order.
Let the interim order shall continue since 2016, since both the courts, so dispose of the report.
For continuation of interim order, I may not, may have some same.
Yes. What is the material that you? What is the material that you produced before court? No. What is the material that you produced before court to prove your possession? Yes.
The very documents produced by the defendants do not itself show that I am.
Not his case. Your case.
Please.
What the material that you have produced before the trial court to establish? What is the material that you have produced?
Page number 52. Plain.
On what basis you are running the library?
Initially,
Where is the government library?
No, it is not a government library.
Then?
It was a school where not government was running the institution.
Government was running.
Government was running.
Well, department is taken action due.
Yes. But subsequently, Lord, since the school was closed, the villagers have commenced the library with the permission of the Grama Panchayat.
How can? Under which law?
Villages not.
Hello, under which law?
Yes. Now they have not for permit license to continue start the library. The resolution was passed by the
Now, where is the license to get?
Subsequently, it was.
Hello, where is the license to run the library?
Subsequently, it was the resolution was passed. Kindly see not the document.
No, no. As on the date of the suit.
Yes.
Whether you produce the license.
Yes, no. Yes, no. Kindly see not the document number. 24/7/2013, the permission given by 27 Charter of Gram Panchayat.
Where are you reading? Where are you reading? Plaint.
Plaint notes, page number 52.
52, yes.
Item number 2, 24/7/2013.
Para number, sir?
Page number 52 of the plaint notes. Item number 2, 24/7/2013. The permission given by 27 Charter of Gram Panchayat to start public library in school building.
To start?
Yes.
You are in possession?
Yes. Subsequently, even prior to that, on 21, subsequently 23/12/2013, the requisition letter from the L&J Ragam Memorial Public Library.
What is the present position now? Library is in operation.
Yes, Lord. Because of the interim order granted by this court, he claimed, petitioner claims that there is no intention and I can close the library. That is why Lord, I have produced the photographs while filing the application for vacating the kindly see not
Yes.
the photograph. Photographs, Lord.
Annexure P below license cancel.
Anyway,
Page 83.
Anyway, he has produced
Yes.
the document insofar as issued by the Panchayat.
Yes.
Whether it has got relevancy or not will
That is a matter of trial.
be looked into by in the trial.
License
Suppose
is
anyway
cancelled.
library is going on,
Yes.
that there will be a imparting knowledge to the people. Not a case for interference.
Moreover, Lord, all the records produced by the
Yes, maybe true. I think let anyway the 24/7/2013 itself permission is given. So
16 cancel. 2016 prior to suit
Where?
Annexure P.
Annexure?
Annexure P 83
Just
cancelled. There was a serious objections raised. Annexure P license cancelled.
ಪರವಾನಗಿಯನ್ನು ನವೀಕರಿಸಿ. That when it was
2016.
17
Suit is also
7/10/2016. When was the suit filed then?
ಪರವಾನಗಿಯನ್ನು ನವೀಕರಿಸುವುದಿಲ್ಲ.
ಲೈಸೆನ್ಸ್ ಮುಗಿತು ಅಲ್ಲಿಗೆ ಒಂದೇ ವರ್ಷ
ಆಮೇಲೆ ಕ್ಲೋಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದೆ.
39/2016 suit is filed.
7/10/2016 is
Yes,
annexure P.
people here raised the objection. He came to know that when it is going to be cancelled. Now your Lordship is the next document.
Yes.
ಬ್ರಹ್ಮಾವರ annexure Q ಮೇಲೆ
When was
ಬ್ರಹ್ಮಾವರ
it?
ಸರ್ಕಾರಿ ಶಾಲೆ ಕ್ರಿಯೆಯನ್ನು ಹೇರದಿ ಇಲ್ಲಿ ತಾತ್ಕಾಲಿಕವಾಗಿ ನಿಲುಗಡೆಗೊಳಿಸಲಾಗಿದೆ. School is closed. This person may not has entered into an entity ಮೇಲೆ calling himself ಗ್ರಂಥಾಲಯ. Now your Lordship is annexure R. And these are all the documents that the trial court did not consider at all.
So the suit was filed on 3/9/16.
3/9/16. Now
Subsequently on next month it was.
ಹೌದು ಮತ್ತೇನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮೇಲೆ ಕೈಲಿಸಿ another document suit file ಮಾಡಿದ
Army kindly seen Annexure R, which gives vital existence of the library.
Just 1 minute. ಇಲ್ಲಿ ಶೂನ್ಯ ಹಾಜರಾತಿ ಕಾರಣ ತಾತ್ಕಾಲಿಕವಾಗಿ ನೀಡು. Even the school is also closed.
School is closed.
Closer of the school, lots of villages have established library.
Where is the material? No material place. It is his own
He himself
document.
has produced lots. He himself has produced Annexure R may kindly be seen lots.
Annexure?
Page number 85, Annexure R.
R.
Annexure R lots.
Yes.
He could not have produced this document, which do not support me. Kindly see not the letter issued by the chief librarian.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಸಾರ್ವಜನಿಕ
ಈ ಗ್ರಂಥಾಲಯ ಚಾಂತಾರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಚೇರಿಯ ಆವರಣದಲ್ಲಿರುತ್ತೆ. It is in ಗ್ರಾಮ ಪಂಚಾಯತಿ ಆವರಣದಲ್ಲಿ ಇದೆಯಾ ಅದು?
ಅಲ್ಲಿ ಅದು ಬೇರೆ ಇದೆ. ಪಬ್ಲಿಕ್ ಲೈಬ್ರರಿ ಬೇರೆ ಇದೆ. ನೆಕ್ಸ್ಟ್ ನಮ್ಮ ಲೈಬ್ರರಿಯನ್ನು ರೆಫರ್ ಮಾಡ್ತಾರೆ. ಉಲ್ಲೇಖನ ಪತ್ರದಲ್ಲಿ 50ನೇ ಹೇಳೂರು ಗ್ರಾಮದ ಸಭೆ ನಂಬರ್ 12/10 1.96 ಸ್ಥಳದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಗ್ರಂಥಾಲಯ ಇದ್ದು ಅಲ್ಲಿಯ ಅವ್ಯವಸ್ಥೆ ಬಗ್ಗೆ ಮಾನ್ಯ ವಿಶೇಷ ಶಾಸ್ತ್ರದ ಬ್ರಹ್ಮಾವರ ವೃತ್ತಿಯವರಿಗೆ ತಾವು ದೂರನ್ನು ನೀಡಿದ್ದು ಇವರು ದೂರು ಕೊಡ್ತಾರೆ. ಈ ಕಚೇರಿಗೆ ಪಟ್ಟಿಯನ್ನು ಕಳುಹಿಸುತ್ತೀರಿ. ಆದರೆ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ದಲ್ಲಿ ಇರುವ ಗ್ರಂಥಾಲಯ ಖಾಸಗಿಯವರಿಗೆ ಸೇರಿದ್ದು ಅದರ ಜವಾಬ್ದಾರಿ ಕೂಡ ಖಾಸಗಿಯವರಿಗೆ ಸೇರ್ತಾರೆ. ಲೈಬ್ರರಿ ಇದೆ ಅಂತ ಇವರೇ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡುವುದು. ಅಲ್ಲಿ ಅವ್ಯವಹಾರ ಆಗ್ತಾ ಇದೆ ಅಂತ. So when he himself admits that there exists a library,
Annexure U may not.
And
My learned
One minute. Just.
now annexure U may be kindly seen. The answer to that letter, annexure due, my lord, page 93. Page 93. Now it is by the registrar of the societies, my lord. Can you see?
What is the stage in the suit?
The suit is trial is yet to be.
Yes?
Trial is yet to be.
What 2016 matter?
Yes, sir. Because of the injunctions they fought between the parties. No, annexure due. Annexure due.
Yes, sir.
ಸಕ್ರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆಯ ಕಾರ್ಯ ನಿರ್ವಹಿಸದೇ ಇರುವುದರಿಂದ ಈ ಶಾಲಾ ಕಟ್ಟಡ ಮಾಡುತ್ತಾರೆ ಸದೈ ಕಟ್ಟಡಗಳಲ್ಲಿ ಹೇಗೆ ಸ್ಥಾಪಿಸಲಾಗಿರುತ್ತದೆ ಪಬ್ಲಿಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ has issued a notice. You are running the library in an unauthorized manner. Now, despite all these documents were produced, my lord, and there is a proceedings of the Udupi Jilla Panchayat. Annexure T is the document which I produced even before the trial court. Annexure T, 87 is proceedings of the Jilla Panchayat. Taking exception to this.
ಸರ್ಕಾರಿ ಕಟ್ಟಡದಲ್ಲಿ ಖಾಸಗಿ ಗ್ರಂಥಾಲಯವನ್ನು ಹೇಗೆ ಸ್ಥಾಪಿಸಿದೆ?
It is not the case of the defendants that it is a public building. Their case that building belongs them. They acquired the property in the year 1974. Whereas it is the plaintiff's case that.
Let the interim order passed by this court shall continue, and I will direct the trial court to dispose. Nothing will happen because the letter addressed by the government itself say that how it has ಸರ್ಕಾರಿ ಕಟ್ಟಡದಲ್ಲಿ ಖಾಸಗಿ. No. Only one more library is there. Not necessary.
By taking interim order notes, they cannot dispose.
Yes,
the plaintiff giving the defendants and the suit notes.
They cannot dispose of you that this petition is filed.
That is the observation notes. That is the status quo continued notes. But if the stay order is granted, there will be no injunction.
Yes.
But I have been running the library notes.
Yes.
So we just start making
this petition is filed by. Please sit down. Please. This petition is filed by the defendants, challenging the order dated 28th January 2020 in MA number 16 of 2017 on the file of the principal senior civil judge at Udupi, confirming the order dated 28th January 2020, confirming the order dated 31st March 2017 in OS number 601 of 2016 on the file of the principal civil judge and JMFC Udupi, allowing the IA number 1, IA number 2 filed by the plaintiff under order 39 rule 1 and 2, rule 1 to 3 of CPC. The relevant facts for the adjudication of this petition are that the plaintiff has filed a suit seeking relief of permanent injunction restraining the defendants from interfering with the possession of the area in which the Heranje late Raghurama Hegde Memorial Public Library, Heranje building and consequential relief. The suit is yes, Heranje is village, yes, and consequential relief of relief. At the time of the filing of the suit, the plaintiff has filed IA number 2 under order 39 rule 1 and 2 of CPC, seeking temporary injunction against the defendants, which came to be allowed by the trial court by order dated 31st March 2017. Feeling aggrieved by the same, the defendants have preferred MA number 16 of 2017 on the file of the first appellate court, and the appeal was resisted by the plaintiff. The first appellate court by order dated 28 January 2020 dismissed the appeal and feeling aggrieved by the same, the defendants have presented these petitions. This petition. I heard Sri S.K. Acharya, Lana Counsel appearing for the petitioner, and Sri V.R. Prasanna, Lana Counsel appearing for the respondent number 1. Sri S.K. Acharya, Lana Counsel appearing for the petitioner, submitted that the petitions, the plaintiffs are not in possession of the land, and therefore the finding recorded by both the courts below requires to be interfered in this petition. In this regard, he referred to the letters enclosed in the writ petition, particularly with regard to annexure. One is U. With regard to the annexure U, dated 19/11/2018, wherein the Registrar of Societies, issued notice to the plaintiffs to provide to the
last sentence.
To shift the library from the existing place on the ground that the library is being constituted without the appropriate license issued by the competent authority. He further contended that just I was full stop. We also contended that as per annexure R dated 27/8/2016, wherein the chief librarian of the district library Udupi has addressed letter to the defendants stating that the said library is a private library and therefore it may not come within the purview of the district central library, not come within the jurisdiction of the central district central library. He also pointed out that as per annexure P, letter dated 7/10/2016, the panchayat, the jurisdictional, the panchayat, Gram Panchayat has refused to continue the license issued in favor of the plaintiff. Accordingly, he submitted that the said letter has been addressed on 7/10/2016 and the suit is filed on 3/9/2016, and therefore he contended that as on the date of the filing of the suit, the library is not existing in the place as such, and the said aspect of the matter has not been considered by both the courts below. Accordingly, he submitted that the finding recorded by the trial court, arriving at a conclusion that the plaintiff is in possession of the property in question, is bad in law. Per contrast, Sri Prasanna V.R. Lana Counsel appearing for the respondent, sought to justify the impugned orders passed by the courts below and submitted that, which is the annexure that you are referred to?
Annexure. R not.
Yes.
Existence of library not is stated. And not annexure P.
Annexure R and T.
R. Annexure T is the Jilla Panchayat resolution. But there is no dispute that the library is in existence.
Which is that annexure R page?
Annexure R not is the
and
page
so and so referring to, referring to annexure R to the writ petition, submitted that the chief librarian, the district chief librarian has pointed out about the presence of the private library in the scheduled property, and also he further contended that which is that or TL page
page number 19 no? Page
90.
page number 87
the Jilla Panchayat Udupi by its general meeting at the 14th general meeting, has
89.
The existence of library is mentioned in page number 90 no?
90.
Page 89, second paragraph.
89.
89 second paragraph. ಖಾಸಗಿ ಸಲುವಾಗಿ ಅಂದರೆ ಶಾಲೆಗೆ ಭೇಟಿಯಲ್ಲಿ ಶಾಲೆ ಇಲಾಖಾ ಅನುಮತಿ ಪಡೆಯದೆ ಗ್ರಂಥಾಲಯ ನಿರ್ವಹಿಸುವುದನ್ನು ಗಮನಿಸಿದ್ದು ತೆರವುಗೊಳಿಸುವ ಬಗ್ಗೆ ಹೆಚ್ಚಿಸುವಾಗಿ ಸ್ಥಳದ ತಕರಾರು ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯ ಪೇಜ್ 89 second paragraph.
Paginated, that's right.
89 90
After T it is not paginated.
Pardon?
After T it is not paginated, that's right.
P ಏನಂತ pagination ಮಾಡಿಲ್ಲ
So, as stated about the existence of the library. In this connection, he submitted that since both the courts below have held against the plaintiff, and therefore the writ petition be dismissed by confirming the order passed by the both the courts below.
One submission was not it is agreed with interlocutory order. It is not agreed with the final order, not granting exemption. Temporarily, the possession of the library, existence of library is not in dispute. Based on the records produced by the defendants alone, we can assume that the library is in existence. It is functioning.
Having heard the learned counsel appearing for the parties, I have carefully considered the finding recorded by finding recorded by both the courts below, and also the interim order granted by this court on 2/7/2021, staying the operation and execution of the orders passed by both the courts below. Full stop. It is not in dispute that the plaintiff has filed a suit for permanent injunction against the defendants. Full stop. Perusal of the documents produced along with the plaint would indicate that on 24/7/2013, permission was accorded by the Chantaru Grama Panchayat by the Chantaru CHATARU Chantaru Grama Panchayat to start public library in the school building. Full stop. The permission granted by the BUO Brahmavara is also been annexed along with the plaint. However, the perusal of the annexure R and P and R would indicate that the said license granted by the Gram Panchayat has been revoked and not continued. And in that way of the matter, I am of the view that since as on the date of the suit and in that view of the matter, there is no finding recorded by both the courts below with regard to as on the date of the suit whether the relevant documents have been considered by the trial court and the first appellate court with regard to the existence of the library as such. And in that way of the matter, taking into account the finding taking into account the documents referred to by the petitioner, particularly with regard to R and T, P, R and T, I am of the view that the impugned orders passed by both the courts below is required to be set aside, and the matter is remitted back to the trial court to consider the IA number 2 afresh after affording opportunity to both the parties and pass suitable orders in accordance with law, taking into account the law declared by this court as well as Apex Court with regard to the granting or refusal of the impugned order, granting or refusal of the temporary injunction under Order 39 Rule 1 and 2 of CPC. Accordingly, the petition is allowed. Orders of both the courts below are hereby set aside. Full stop. Yes, next. ಇದೊಂದೇ ಅಲ್ಲ ಪಾಸ್ ಓವರ್ ಇದು 232. Yes.
230 matters. Serial number 62. R. Kotwal.
R. Kotwal? Yes, ma'am. Yes. What your challenge, sir? This is with regard to court fee. Suit for?
Suit for declaration and permanent.
Suit for declaration and injunction. Suit for declaration and injunction. Yes, sir. Yes.
The impugned order is at page number 88.
What is IA 3 actually? What is IA 3?
IA number 3 is filed by the plaintiff, your lordship, with regard to directing the defendant to pay the proper court fee, your lordship.
Defendant?
Please, your lordship.
Directly defendant to pay court fee?
Please, your lordship, because they have filed counter-claim application, your lordship.
Very well.
Please, your lordship.
So they have filed counter-claim also.
Please, your lordship.
Yes. What the court said? What happened?
Your lordship, the court has said that they have sought for mandatory injunction, and they have paid the proper court fee, your lordship.
26, section 26C, yes.
Please, your lordship. I take your lordship to page number 64, your lordship.
64.
65, your lordship.
65.
65,
Yes, sir.
that is the return statement and counter-claim.
Yes, what is the counter-claim that?
Counter-claim, plaintiff is a prayer, your lordship, which is the page number 79.
79.
Please, your lordship.
Yes, sir.
Yes, dismiss the suit filed by the plaintiff with exemplary clause.
Directing the plaintiff to vacate and...
Directing the plaintiff to vacate.
Yes.
And hand over the keys of the premises in suit scheduled property to defendant
Yes,
number 1 and 3. Here, your lordship, I asked them to pay the proper court fee, your lordship, because your lordship, they have not even proved their ownership and title over the suit scheduled property. They are directly asked for mandatory injunction. This price cannot be sustainable, your lordship, without seeking declaration. They cannot ask for injunction, your lordship. This is well set up principle of law, your lordship. They have not paid the court fee, your lordship.
Yes, sir.
Your lordship, the preliminary fact of the case, your lordship, I am the owner. I have purchased the property in the year 1999, your lordship.
1999.
Please, your lordship.
Yes, sir.
And since then, your lordship, I am in the possession of over the suit scheduled property, your lordship.
How they have valued the counterclaim actually? How they have valued the counterclaim?
They have valued one. They have only sought for mandatory injunction.
Yes.
Since they have paid only 25 rupees as court fee.
Yes, 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 madam.
When they are not.
Yes.
My lord, my case is that plaintiff is in permissive possession of defendant, my lord. And hence,
That is, you refer to the
Yes.
paragraph in the...
Can I cite two judgments?
Just a minute. Facts, let us understand the facts. I think on the last occasion you read
Yes,
one of the paragraphs in the legal
That
statement.
is in page number 57, your lordship.
67, 1 minute.
57, paragraph number 9.
paragraph
Which
number
they have
Just 1 minute, sir. 1 minute. Paragraph?
Nine.
It is in permissive. Yes.
It is in permissive. My lord, the plaintiff is none other than my vendor, my lord. They are my vendors. They might dispute the document.
Yes.
That is a matter of trial.
Yes.
Whether that was genuine or not is a matter
Yes.
of
If
trial.
it is a permissive, then there's a
Mandatory injunction is what I have
So
said.
you are also trying to take paragraph 6 of their one contact agreement.
of the written statement.
Of the return.
6. Yes. What day?
Each defendant further submitted plaintiff has further received additional. Your Lordship, additional advance or sale consideration in amount in sum of rupees 10 lakh on 8/12/2008 and admitted at same status. It is further submitted that furtherance of the receipt of the accounted amount, the plaintiff has executed power. Kindly note this, Your Lordship. Power of attorney dated 22/11/2008, which is notarized, Your Lordship. Appointing P.R. Satyanarayana, that is defendant number 4 as an agent with power to transact the suit scheduled property. In the Your Lordship, this power
Whether the issues have been framed?
challenge, Your Lordship.
Whether the issues have been framed?
No, Your
No,
Lordship.
my lord, the suit is stayed, my lord.
Suit is stable. That's
Nothing
what.
has been.
Your Lordship, they are claiming the ownership under the alleged sale, which is already in challenge, Your Lordship.
Yes.
And Your Lordship, kindly see my plaint, Your Lordship. Government made in the plaint, Your Lordship. My Lord, my plaint is at page number 49, Your Lordship.
Let us will see. Told. Yes.
Your Lordship, my only submission is since from 1999 I am in possession and I have produced all the relevant documents before the trial court in order to prove my ownership.
Yes.
They are seeking only mandatory injunction which cannot be permissible, Your Lordship. They should seek declaration, then mandatory injunction, Your Lordship.
Yes. Have you filed the rejoinder to the written counterclaim?
Your Lordship, I have not.
Because since they have
Immediately
claimed,
I filed the IA number 3, Your Lordship.
no, that's it. Apart from filing written statement, you were applying. They made a claim for counterclaim, for which you should have filed a rejoinder.
By then I have filed
No,
IA number 3, Your Lordship.
That's why the learned judge is right. However, anyway, suit is issues are not framed. Let the court will frame even issue on the said aspect. Told. This writ petition, please answer. This writ petition is filed by the plaintiff, challenging the order plaintiff in OS number 5335 of 2012 on the file of the 5th Additional City Civil Judge, Bengaluru, challenging the order dated 17th December 2018, rejecting the IA number 3 under section 29 of Karnataka Port Fees and Suit Valuation Act filed by the plaintiff. The relevant facts for the adjudication of this writ petition are that plaintiff has filed a suit against the defendants seeking relief of declaration with consequential relief of permanent injunction restrain the defendants from interfering with the associative property. The defendants entered appearance and filed a written statement, denying the averments made in the plaint, and also sought counterclaim in the suit. In the meanwhile, the plaintiff has filed IA number 3 and order 29 of the so-and-so Karnataka Court Case Act, hereinafter referred to as so-and-so Act, directing the seeking direction to the defendant to pay the court fee, since the defendants have sought for the relief of mandatory injunction in the counterclaim filed by them. After hearing the learned counsel appearing for the parties, the trial court by impugned order dated 17th December 2018 rejected the IA number 3. Feeling aggrieved by the same, the plaintiff has preferred this writ petition. Now, learned counsel Mr. So-and-so appearing for the petitioner contended that the relief sought for by the defendants in the counterclaim itself is not maintainable, as unless the defendants claim relief of the declaration with consequential relief of possession. In that view of the matter, he submitted that the finding recorded by the trial court rejecting the IA number 3 filed by the plaintiff is incorrect, which requires to be interfered in this petition. Per contra, Madam So-and-so and a counsel appearing for the respondent, invited the attention of the court to the paragraph 9 in the written statement and the counterclaim filed by the defendant, and submitted that the plaintiff is in permissive possession of the suit scheduled property, and it is not disputed in the plaint that the defendant is not the owner of the property, and therefore the relief sought for in the counterclaim, issuing direction to the plaintiff to vacate and hand over the keys of the premises in the suit scheduled property is just and proper. With regard to the same, the defendants have paid the court fee under section 26 clause C of the Act, which is just and proper, does not call for any interference in this writ petition. Having heard the learned counsel appearing for the parties, I am carefully considered the prayer made in the plaint as well as the prayer made in the counterclaim filed by the defendants as per annexure B. It is the case of the defendants before the trial court that the defendant is the owner in possession of the land. It is the case.
Yes, sir.
It is the case of the defendant that the Please, either you dictate or I will dictate.
It's the case of the defendant with the trial court that the defendant is the owner.
It is a case of the defendant. The defendant is the owner of the property and allowed the plaintiff in permissive possession of the suit scheduled property since 6/11/2009, and therefore the claim is made with regard to seeking relief of mandatory injunction directing the plaintiff to vacate and hand over the keys of the premises in question. In that way of the matter, the trial court, having taken note of the provisions contained under section 26C of the Act, has held that the court fee paid by the defendant is just and proper, and I am of the view that there is no illegality in the order passed by the trial court. Accordingly, the writ petition is devoid of merits and accordingly rejected. Yes. It is also made clear that since the issues are yet to be framed in the suit, and therefore the trial court is at liberty to frame the issue relating to the pleadings on record, including the court fee, taking into account the relief sought for by both the parties. Yes.
63 is Somsekhar.
Yes, sir.
An ex parte judgment and decree was passed.
Yes, sir.
In challenge before the Honorable Court, that matter is pending, the matter is submitted.
Where is in which case it is pending?
RSA.
RSA.
Yes, RFP.
RFP.
1364/2017.
1364 of 17. It is pending consideration.
Pending consideration.
Any order is passed by the.
Order was passed subject to payment of 50%.
Yes, sir.
But if the judgment has tried to deposit the amount and matter is pending.
Whether it is deposited?
No.
Why?
We didn't have any means to deposit.
Can decree.
So, as a matter of fact, I made a submission. It's a decree. In the meantime, you just filed an execution petition.
Yes.
And a notice was ordered.
Yes.
He appeared before answering to their show cause notice. The learned issued an arrest warrant.
Yes.
It is a settled principle and law that it is mandatory provision to hold an inquiry to establish the means and that has to follow the procedure before I issue an arrest warrant. That is the only point involved in this matter.
Yes, sir. Correct.
If the Honorable Court considers that point, the matter has to go before the court below and it has to be
yes,
followed all the procedures and then
yes,
it can be decided.
What's the procedure to be followed?
Right, show cause notice, I have to declare the show cause notice. When the matter
Under
was-
which provision has to be completed? Under which provision has to be completed?
Yes, Order 21, Rule 37 to 40.
Order 21?
Rule 37 to 40.
37.
Notwithstanding anything in this.
Arrest and detention in the civil prison.
Yes, sir.
Yes, sir.
Notwithstanding anything in these rules, while an application is for execution of a decree of payment of money by the arrest and detention in civil prison of a judgment debtor who is liable to be arrested in pursuance of the application, the court shall, instead of issuing a warrant of arrest, issue a notice calling upon him to appear before the court on a date to specified in the notice and show cause why he should not be
Committed to civil prison.
That option has to be given. I have to answer that point.
Hmm.
And
So according to you, such notice is not issued to you.
notice is issued. I appeared. Opportunity is not done very next. And the day itself.
The issue you appear, that itself is an opportunity.
Yes, sir. Opportunity to answer.
That you have to answer.
Yes, madam. Opportunity. Sufficient opportunity has not been given to answer that. Even otherwise,
You had appeared before the court.
Yes, madam.
Then?
Then the arrest warrant was issued. I sought the
Then what is your reply? What is your?
Thus, I sought time for filing an objection and to answer the notice.
So what objection that you think?
Whether or not the decree order has to be established to have the means to
Yes, sir.
comply the judgment and decree passed by the court below.
Yes.
And thereafter, the court has to satisfy the.
Correct.
You should have the means.
Yes.
And then to proceed. And before that, they have to deposit the bata before the court. Before issuing the arrest warrant.
Even
all these procedures are not being
even
followed.
inquiry has to be conducted.
The inquiry has to be held.
Yes, sir.
After the institution of the execution proceedings, notice was issued to him, and he did appear before the executive court, not at once, more than 2 times.
Yes, sir.
And he did not offer any objections thereto.
Yes.
And thereafter, he kept himself quiet. I had no other hope but to take a system for issue of
Yes.
for his arrest, for recovery of 14,59,000 paid and agreement to sell.
How much?
Originally, the suit was instituted for.
When will be the next date of hearing?
Please, Madam.
When will be the next date of hearing?
Next date of the hearing, I am not aware.
When will be the next date of hearing, sir?
I am unaware of the next date of the hearing. This was the money which I paid it to him under the agreement to sell on different dates. In the meanwhile, when the suit was pending.
Anyway, by next date of hearing, that he will file objection on the very same day, court will consider and pass orders. That is better. Because straight away sending the man.
If my amendment's argument is to be understood, after issuance of the execution notice, a show cause notice to be issued. No, that is not. The notice itself will show cause. Why execution proceeding cannot be taken against you? That itself is a show cause notice.
For certain, by next date of hearing letter, what will be, when will be the next date of hearing?
That I am not aware of.
ನಿಮ್ಗೆ ಗೊತ್ತಾ ಸರ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತು ಆರ್ ಎಸ್ ಸ್ಟೇ ಆಫ್ ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗಿಬಿಟ್ಟಿದೆಯಾ
ಇಲ್ಲ, for a limited period of time. Thereafter, this interim order was not continued.
ನೋ ಇಂಟ್ರಿ ಮಾಡಕ್ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ ಐ ಥಿಂಕ್ ದಿಸ್ ಕೋರ್ಟ್ this 7/3/2019
Yes.
this court has said the executing court shall not implement the order dated so and so. I think if such been the case, next date,
Next date of hearing.
irrespective of the same next date of hearing, let you will file objection.
Please.
Third. Please, sir. This petition is filed. Please, sir. This petition is filed by the JDR 1 and 2 in execution petition number 3578 of 2017 on the file of 20th Additional City Civil and Session Judge Bengaluru, challenging the order dated 5/1, challenging the order dated 6/2/2019. 16/2/2019. 16/2 ಅಂತ ಇದೆ. ಪೇಜ್ 54ರಲ್ಲಿ ಇದೆ. Page 54 ಅಲ್ಲಿ it is reflected that 16/2 ದಸ್ತಗಿರಿಗೆ ಹೋದ 16/2 full stop. The relevant facts for the adjudication of this petition are that the plaintiff has filed suit in OS number 294 of 2012 on the file of the trial court and seeking relief of specific performance, and the said suit came to be disposed of by judgment and decree dated 6th April 2017, decreeing the suit in part, and thereby the court directed the defendant number 1 and 2 to pay sum of rupees 14,59,000 with interest at the rate of 6% per annum from the date of entering into agreement till the date of realization. It is forthcoming from the writ petition papers that feeling aggrieved by the said judgment and decree passed by the trial court, the JDRs have filed RFA number 1364 of 2017 before this court, and the appeal is pending consideration. It is also extracted in the order sheet in the execution petition 3578 of 2017 that this court has directed the JDRs/petitioner herein to pay to deposit 50% of the decretal amount before this court, and the said interim order passed by this court in RFA number 1364 of 2017 is not complied with, and accordingly the decree holder / respondent herein, has sought for issuance of arrest warrant against the JDRs, culminating in passing of the order dated 16/2/2019 by the executing court. Feeling aggrieved by the same, the JDRs have approached this court. I have heard Sri so and so, C.R. Gopal Samil and a senior counsel appearing for the petitioner, and Mr. so and so Arya Devanand and a counsel appearing for the respondent. C.R. Gopal Samil and a senior counsel appearing for the petitioner invited the attention of the court to the finding recorded by the executing court, as well as the provision contained under Order 21, Rule 37 of CPC, and submitted that an inquiry has to be conducted before the executing court passes an order sending the judgment debtor to the civil prison. Accordingly, he submitted that the said procedure has not been followed by the trial court, followed by the executing court, and accordingly he submitted that the impugned order is liable to be set aside. Per contrast, Sri Arya Devanand Lanand, counsel appearing for the respondent/decree holder, invited the attention of the court to the order sheet dated 5/1/2019 in execution petition number 3578 of 2017, and submitted that the JDRs have not complied with the interim order passed by this court in RFA number 1364 of 2017, and the JDRs are dodging the matter without complying with the judgment and decree passed by the trial court in OS number 2945 of 2012. Accordingly, he submitted that since the since the JDRs are failed to pay and comply with the order passed by this court in RFA number 1364 of 2017, there is no illegality in the impugned order passed by the trial court. Accordingly, he sought for dismissal of this writ petition. In the light of the submission made by the Learned Counsel appearing for the parties, it is not in dispute that the JDRs / petitions herein have suffered an order in OS number 294 of 2012, dated 6th April 2017. It is also not disputed by the parties that the said judgment and decree passed by the trial court is challenged before this court in RFA number 1364 of 2017. And this court has granted an interim order, staying the operation of the judgment and decree, subject to the payment of 50% of the decretal amount by the appellant therein / petitions herein before this court. However, perusal of the record, particularly with regard to the order sheet maintained by the executing court, would indicate that the JDRs are not complied with the said order. Be that may be so. However, looking into the language employed in Order 21 Rule 37 of the CPC, wherein the trial court is the executing court, before issuing the arrest warrant, ought to have conducted an inquiry, and thereafter pass the appropriate orders considering the case on merits. Full stop. No doubt, the procedure prescribed under Order Rule 40 mandates that an inquiry has to be Rule 40 of Order 21. Yes. Mandates that an inquiry has to be conducted before executing court passes an order sending the judgment debtor to the civil prison. However, taking into consideration, the impugned order passed by the executing court, wherein such a procedure has not complied with. However, I find, accordingly, I am of the view that the impugned order passed by the executing court issuing arrest warrant against the JDRs / petitioner is incorrect and liable to be set aside. However, I find force in the submission made by Sri Arya Divanan and a counsel appearing for the decree holder that though the judgment and decree passed by the trial court in OS number 294 of 2012 on 6th April 2017. However, the decree holder is not able to secure the fruits of the decree. It is also not disputed by the parties that this court has granted interim order of stay of the judgment and decree in OS number 2945 of 2012, subject to directing the appellant therein / petitions herein to deposit 50%. However, the same has not been complied with. In that way of the matter, I am of the view that, in the ends of justice, an opportunity be given to the JDRs to file objection to the application / to the main petition in execution petition number 3578 of 2017 on the next date of hearing, and the trial court and the executing court shall consider the same and pass suitable orders in accordance with law within outer limit of 2 weeks from the receipt of such objection from the JDRs. 13. By next date of hearing ಅಲ್ಲಿ bracket ಹಾಕಿ 13, that is Wednesday 13th 4 ಅಂತ ಮಾಡಿವಿ. and thereafter then Raja banbiduttare. Within 2 months antala. Within 2 months. Raja barutte.
I don't know why bad things are happening to the good people.
Within 2 months thereafter antala. Yes, very well.
64, the Madhya
Yes. You find any case law on this point, sir? I think I also.
HCG contractors and the.
But that is not insofar as the commercial court is concerned.
It's a commercial court.
Huh?
Commercial court.
But this is commercial court.
Yes.
I think you cannot get the benefit of even the order of the Supreme Court in suo motu also.
Yes.
Because these proceedings were prior to that one.
Correct. I have on the last date of occasion, my letter was not contained. I passed on one occasion on the High Court.
Which one? Which one, sir?
There it is, irrespective of pandemic or not.
Yes. But insofar as the Supreme Court judgment on this point say that even Honorable Justice Dinesh Maheshwari also. The Devi anta undiದೆ. Devi alla?
That is SCG contractors.
That has been considered.
That is after consideration.
Yes. Devi. Even if you go through this, sir, the 120 days is mandatory. That's what the Supreme Court said in 2022, SCC Online Supreme Court 180.
This is also delivered in 2022.
Which is that? No, this is by the Supreme Court, Honorable Supreme Court.
I am
Civil Division petition.
Which one?
Amoda ILSP.
Civil CRP. That is Andhra Pradesh. What the court said that? This is on 25/1. This is on February 14th by the Supreme Court. Subsequent. Not Supreme Court. Correct. That is the date. In the suo motu proceedings, this Honorable Supreme Court say that only between the said period. That period is stipulated. That is on 15/3/2020 to 28/2/2022, excluding these days plus 150 days. Yes, please. Have you gone through this judgment at least? The Supreme Court judgment. That is DV Projects Limited. Yes, go to Supreme Court judgment. Leave this High Courts for a while. Directly you can go to Supreme Court judgment. If applicable or not, will be looked into. Yes, sir.
Order rules 110, order 5 rules 1 commercial codes and 4 of 16.
Which judgment you are reading, sir? That's a judgment of the Apex Court. Now go to relevant para. Time limit for filing return statement and consequences of default. Para 47. You go to para 49, it will be the relevant. Insofar as Order 7 Rule 1, Order 8 Rule 1, of course the period of excluding is there. But insofar as paragraph 49 is with even SCG contract has been considered.
Article also has the same thing. I got it from because paragraph numbers will differ from.
Oh, differ. Very well. It is reported. DV.
I got it from civil court.
ಬರೆದಿಟ್ಕೊಂಡಿರ. ಎಸ್ ಸರ್. ಪ್ಯಾರಾಗ್ರಾಫ್. Yes, sir. Which para, sir?
Before I start, but I have to ask me to give the date of transfer.
Yes, sir.
On the date of last hearing, asked me to give the exact date of transfer from the I got a wrong date to the website. So the offender notification will get returned.
Okay, when do you want? 13. Kodana, sir. You will get some material. So when it was transferred from.
We don't know exactly when it was transferred.
Very well. Opportunity will be given. This copy I will keep it with.
Both of them.
Yes. Very well.
Website will take it for this.
Very well. At the request made by the Lana Council appealing for the petitioner to enable him to get certain information regarding the transfer of the suit from the regular civil code to the commercial code. List on 13. Budvara.
As well as now we know it is only.
Very well.
We don't know exact date.
Very good. 231. B group. 230 only. Sir, 230 on the very side. 231. B group matters.
B group matters. Serial number 44. Sidmalappa PM. Sidmalappa PM.
Siddamalappa, Rahul S. Reddy.
I appear for the respondent number 1 to 4, Your Lordship.
Yes.
Please, my lord.
Yes.
Lord,
Your Lordship's kind intervention. Before my learned friend would start, there are 2 petitions filed for the same.
No, I will have clarification over it. I will have a clarification. I will submit my clarification.
Yes.
Lord, 2 writ petitions are filed. Lord, in both the writ petitions, Lord, one and the same impugned order, Lord, are the subject matter. Lord, I have also submitted already. Lord, now my claim, Lord, in both the writ petition restricted only to the only with respect to suit schedule item number 5B, 5A and 5B of B schedule property.
Suit item 5B,
A and B. A and B.
5A and B.
B. Not remaining, Lord, which are all, Lord, administrative, Lord, ancestral property. These 2 properties are claims to be the properties of Lord self-acquired of first defendant, Lord.
Suit
for partition is filed.
Yes, sir.
Lord, my submission is, Lord, Anumaya, Lord, is the father.
Yes, sir.
Anumaya is the father who died on Lord 4/6/1990.
You are a defendant before a trial court. Yes, sir.
Lord, I am defendant 1 to 3. The petitioners are defendant number 1 to 3.
Yes.
Lord, among them, Lord, the second petitioner, Lord, she is the wife of first defendant. The third petitioner is the wife of first petitioner.
Yes,
that
sir.
is first defendant's wife.
Yes, sir.
Lord, my submission is father died on Lord 4/6/1990. This date is too relevant for consideration. 4/6/1990.
1990. The father of the defendant died.
The father of plaintiff and defendant. Yeah,
Yes.
except defendant number 8 and 9.
Yes.
Lord, after that, Lord, the suit in OS 317/1999 came to be filed by one Lakshmi Devamma.
Yes.
Lord, the suit came to be decreed for partition on 17/11/2006. 17/11/2006.
17/11/2006. Yes, sir.
And Lord, final decree proceedings was also concluded.
Yes.
Apportionment of share is not assigned to the sharers. Lord,
Yes,
this
sir.
was the stage. All these things are suppressed and the suit is filed by Lord elder members of the family
Yes.
who are elder brothers
Yes,
against
sir.
a junior member of the family.
Yes.
The only grievance is that Lord, the first defendant purchased property, suit schedule item number 5A,
Yes.
under a registered sale deed dated 17/12/2018.
Yes, sir.
2018.
Ah.
After lapse of Lord 28 years
Yes.
to the date of death of the father.
Yes, sir.
Lord, and the third petitioner, wife of first defendant, purchased Lord suit item number 5B under a registered sale deed dated 17/12/2018.
Correct.
These are Lord the only two properties to the extent Lord we are aggrieved. Lord, there is an order, prohibitory order by way of temporary injunction restraining us from alienating the suit property. These
Yes.
items the property. To the
Yes.
extent of other properties are concerned, Lord, we straight away concede and we will face the trial and we will have our result.
Correct.
Lord, these properties are self-acquired.
Yes.
Lord, this fact has not been considered by the trial court.
Yes.
And particularly, Lord, the third petitioner,
Yes.
she is a lady. She is not a member of the family and not
Yes.
even a co-person. Not
Yes.
even a co-person.
Yes.
And again, our property is also not an interim order is granted.
Yes.
Lord, in both the writ petition, Lord, by mistake, two writ petitions were filed. We restrict only, Lord, to this extent of the relief is concerned.
Yes.
Lord,
I think already an order has passed by this court on 17/12/2021.
No, I had my submission to this extent, Lord, that was accepted by the court.
Let I will call this matter on both on some other day so that.
Lord, my request,
Yes.
Lord, to the rescue of the plaintiff, Lord, section 53A is already there.
Yes, sir.
For that reason, Lord, at least we may be permitted to not raise loan because we are running our own petty business. Lord, because of COVID-19, we are suffering from financially. And
Yes.
we find it not very difficult to run the business.
No,
We are
yes.
unable to
No, I
raise
will,
the loan.
No, sir. Both the matters will be called next week itself. Let us see.
Lord,
Or,
only short accommodation, Lord, we may
Very,
be
very
permitted to raise loan, Lord, at least.
Very well.
And, we will take risk of discharging loan on that.
ನಾಳೆ ಮಧ್ಯಾಹ್ನ 2:30 ಇದೆ ಯಾರಿಲ್ಲ tomorrow 2:30 sir.
Please, my lord, please.
Registry is directed to first of this court by order dated 17/12/2021 directed the registry to tag WP number 10839 of 2020 along with the said petition.
Tag ಆಗಿದೆ.
Tag ಆಗಿದೆ but
ಹೌದು ಇದೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ ಇವತ್ತು ಎರಡು ಮ್ಯಾಟರ್.
ಹೌದು ಸ್ವಾಮಿ, two matters have come up with my lord.
The other connected matter is connected.
Oh yes sir, yes. Oh, that's in the next page. Yes, very. Yes, so then yes, please argue, sir.
Tomorrow, please, Lord.
Illa better. Now we can continue anyway.
Please.
I was under the impression that matter is not connected. That's
Please. Lord, I already submitted. Lord, this is a suit for partition filed by the elders of the family, elder brothers.
Yes.
Lord, the first plaintiff is the eldest among the male members.
Yes.
Second plaintiff is next brother.
Yes.
And third one is third brother.
Yes.
Lord, the first petitioner is the fourth brother.
Yes.
Lord, plaintiff number 4 is the fifth brother.
Only in so far these properties which have been
Only two
purchased by
items
you.
of the property I am
That is-
not
yes.
insisting this honorable court to consider.
Yes. But there is no finding by the court below relating to the said sale deed.
No, the sale deeds were not considered and also not considered the status of these petitioners.
Yes. Correct, sir.
They are not the elder. They are younger.
Yes,
in the
Mr.
family.
Rawat. Yes, Mr. Rawat.
Your Lordship, my submission is, Your Lordship.
Yes,
My
maybe,
learned
but
friend-
what
Yes,
has
sir.
happened
Hmm.
in just you go to page 88, order passed by the first appellate court in MA 1 of 20, para 22, he
Yes,
raised
sir.
the fact that these properties that he has purchased on 25/10 and 2018.
Yes, Your Lordship.
There is no finding by both the courts below relating to the same.
Your Lordship, my submission is these properties which which the petitioners have purchased, that is 5A and 5B.
That
These
according to that may be out of the joint
no,
place.
no.
That
These,
you may raise.
Your Lordship, these properties were the schedules. Like joint family had entered into an agreement of sale in the year 2008 with respect to these properties.
Yes.
We have a
But
agreement to
irrespective of the
sell.
same, there will be some finding to that effect.
Yes, Your Lordship. There is an agreement of sale in my plaint, Your Lordship. If Your Lordship may kindly permit me, page number 16, Your Lordship.
Page
Plaint,
number?
16, 16.
No, you go to interim order, the impugned orders passed by the court below.
Yes,
Whether the said aspect has been considered.
No, Your Lordship, the said aspect has not been considered.
Then,
My
if
contention.
it is not considered, then if it is not considered, it is incorrect on the part of the courts below.
Your Lordship, the aspect which the said properties were a part of agreement of sale has been considered. In the year 2008, the said property.
Agreement is considered, but what about the sale deed?
Sale deeds, Your Lordship, out of the joint family income, the defendant number one has
But
purchased
as per
on
these,
his own name.
As per these two sale deeds, it stands in the name of the petitioner's hearing.
Yes, Your Lordship, petitioners here. They have purchased it through the joint family. Your Lordship, schedule number, I would like to.
Then do one thing, you can maintain status quo better than.
Yes, Your Lordship, maintaining status quo is not a problem, Your Lordship.
Lord,
What is the position, sir? What is the
my
position now?
submission is maintaining status quo and restraining me from alienating, both are one and the same.
Your Lordship, tomorrow definitely the property will be sold. Your Lordship, schedule number 7, 8, 9, and 10 are the businesses held by the defendants and the
Lord, my request, if my learned friend
the
having
said
such
property,
just a minute.
Feeling, Lord, I may be permitted to raise loan on this, and it is my personal liability.
The said properties have been purchased through the income
You
taken
can
from
file
schedule
an,
number
you can,
7,
you can
8,
file
9,
an,
and 10.
Yes, 1 minute. You can file an appeal that you can raise loan, but you will be personally liable for the same.
Please.
That could be.
Lord,
Yes,
the equity will always on the plaintiff. Lord, they can
Yes.
have Lord opportunity their share.
Because already
The
when
other
you are-
properties,
yes.
major properties are there.
When
These
you
are
are going
small properties.
when you are going to file this?
Lord, tomorrow itself I will file it. Lord.
Tomorrow then. Well, sorry. Tomorrow afternoon 2:30.
If
Please,
Your Lordship can have it on Monday, Your Lordship, tomorrow.
ಇಲ್ಲ 2:30.
Monday ಆಗ್ಬೋದು ಸೇಮ್ ಇದೇ ರೆಕಾರ್ಡಿಂಗ್ ಆಗಿ
We have ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್. This tomorrow at 2:30 to enable the petitions hearing to file the affidavit undertaking full stop. Next matter.
45, Sri Karnataka, please.
Yes, Madam.
I appear for respondent number 102.
Yes.
I have filed a notice of conduct on 28/2/2022, but my name not shown in the constitution.
ತಮ್ಮ ಹೆಸರು
Ganpati, senior name Ganpati Bhatt.
Mr. So and so submitted that, he has filed power on behalf of the respondent number 1 and 2. Registry is directed to print the name of Mr. So and so in the cause list. ಇನ್ನೊಂದಿನ ತಗೊಳ್ಳ
ಯೂಶುವಲ್ ಸ್ಟೋರಿ ಮನೆ ಸೊಸೆಗೂ ಹೆಣ್ಮಕ್ಳಿಗೂ ವ್ಯಾಖ್ಯಾನ
ಅದೆಲ್ಲ
ಡೆಪಾಸಿಟ್ ಕೇಳಿದ್ವಿ ಅದಕ್ಕೆ ಸಾಕು.
There's every alternative brief. Next matter.
Yes, brother.
That's the next brief. ಯಾವತ್ತು
Week after next. Next week ಬರೋದಿಲ್ಲ. Week after next.
20th, sir? 20th. Yes.
Even about 46, Sri Prasad Kayar, Sri Prasad Rao.
No representation. List after summer vacation.
Serial number 47, serial number 48, Sri Prakash Kemet.
Prakash? Yes. Dependency. Suit person?
suit for specific performance.
ಶೀಟ್ ಇಟ್ಟಿದ್ದಾರೆ
Filed by the
ನಾಳೆ
respondent
2:30 ಸೂಟ್ ಫಾರ್
Suit for specific performance. I request my lords to kindly turn to synopsis produced in the red petition.
ಸಿನಾಪ್ಸಿಸ್ ಇದೆ ಸಿನಾಪ್ಸಿಸ್ ಏನು
Red petition synopsis, please.
ರಿಟ್ ಪಿಟಿಷನ್ ಸಿನಾಪ್ಸಿಸ್ ಎಸ್ ಸರ್
Lord,
ಯು ಆರ್ ದಿ ಡಿಪೆಂಡೆಂಟ್ ಎಸ್
yes,
ಎಸ್
there was submission of the written statement belatedly.
Yes.
By that time, Lord, in view of closure of the stage for filing the written statement, the plaintiffs have laid evidence of PW on it. And thereafter, on application filed by the defendants, the order of recall and the petition.
Then you
for
filed a written
statement. There are towards the issues of framed.
Yes, sir.
And subsequently, Lord, there was further examination in chief of the witnesses.
Yes, sir.
Lord, thereafterwards, the matter was settled for mediation and it was not settled.
Yes, sir.
But what happened on 9/2/2021?
Yes.
6/1/2021, Lord,
So you filed an application to cross-examine
because
PW.
because of the absence of the
Yes.
petitioner's advocate, it was closed.
Yes.
And immediately there was an application.
Yes,
filed
Mr.
and
Pawan.
it was reopened.
It's a principles of natural justice.
And there, after cross-examination, Lord, an application was filed immediately. What happened? The cross-examination of the PW2 was inadvertently not noticed, he was not at all subjected to cross-examination. That's one thing. And for further cross-examination of PW1, and there is no delay. Immediately at the closure of the cross-examination, the
Yes, Mr. Pawan.
Lord, kindly come to my Lord, page number 14, my Lord, annex area.
I hope you have not strong
Yes.
objections for violation of principles of natural justice.
No, yes, my Lord, if it is so, if he, what he said, it is the ultimate, it is there, my Lord, I don't have any objection.
Yes.
The facts is not like that.
Yes, sir.
Running page number 36, my Lord, annex area.
Only thing is now the stage is for the defendants. Let
Your
will
Lordship, kindly-
do one thing. Let the by next set of hearing, let the will cross-examine.
Kindly introduce my Lord application, running page number 36, annex area.
36.
Yes,
1 minute. Sir. Yes, sir.
this is the application. 36.
Yes, sir.
It's a recall or it's
Reopen the case from
reopen and
defendant
recall.
to
Cross next page, my Lord, none of facts. Then your Lordship may kindly come to running page.
ನಾರ್ಮಲ್ ಅಲ್ಲೇ ಕೂತ್ಕೊಂಡು ಬರೆಯೋದು ಕಾಮನ್ ಇವೆಲ್ಲ.
ನಾನು ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳ್ತೇನೆ. Next, running page number 40, annex F.
Yes.
Reopen.
Okay.
Please.
I will say the last opportunity with cost. With cost.
Kindly come to my Lord,
With cost we will do. These are all the things.
one sufficient name. Kindly come to my Lord, reason of the learned trial court.
Yes.
Running page number 70.
Correct. Para 7.
Yes. The suit is filed for relief of specific performance of contract. Now the stage is for defendant evidence. At this stage, the defendant come up with the certification seeking permission to recall PW1 and other witnesses for the purpose of further cross-examination. The same was opposed by the plaintiff, admitting PW1 and other witnesses are already cross-examined.
Yes.
The defendants have not stated with respect to the aspect, in which aspect they have intent to cross-examination. That is my Lord blanket. That is not the my Lord. I want to say before my Lord.
Yes. By cost it will. By next set of hearing. By next set of hearing without fail, please.
One date my Lord, please.
That's all. That's all. My next set of hearing, whichever the date is there, on that day, please cross-examine close.
Kindly fix or time limit.
No, anyway.
Suit for specific performance.
No, even otherwise, I think next when will be the next set of hearing?
4 years in the medical. 2018. I have no idea.
Next set of, but just I will say next set of hearing.
Within 4 months, my Lord.
No.
6 months.
ಇನ್ನು 2018 ಮ್ಯಾಟ್ರ್ 1 month ಫೈಲ್ ಮಾಡಿ.
ಅದೇ ನಾನು ನೋಡಿ ನನ್ನ ರಿಪಿಟೇಷನ್ ಅಲ್ಲಿ ಅವರು ಕ್ಲೋಸರ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದರಲ್ಲಿ
This third is this petition. Please Raj. This petition is filed by the defendants. in OS number 84 of 2018 on the file of the first additional senior civil judge Chikkamangaluru, challenging the order dated 24/2 24 annexure H when is what?
Yes.
24 to 2021, rejecting the IA number 11 filed under order 18 rule 17 of CPC. On IA number 11 and 12, both are dismissed. Yes. The relevant facts for the adjudication of this petition are that the plaintiff has filed suit seeking specific performance of the agreement dated 23/3/2017, coupled with the relief of permanent injunction restraining the defendants from interfering with the suit schedule property. Perusal of the writ petition would indicate that, the petitioners hearing / defendants have filed a written statement at the belated stage, and by the time that they filed the written statement, the evidence of the chief examination of the PW1 was concluded. PW1 and 2, PW1 and PW2 is concluded. Thereafter, the defendants entered appearance, filed detailed written statement, and in the meanwhile, the defendants have filed application in IA number 11 and 12, seeking recall the PW1 and to permit them to cross-examine.
We have cross-examined PW1.
For further cross-examination.
Further cross-examination and for cross-examination of PW2.
That is 42. 1 minute. Yes.
Thereafter, the defendant has filed
two applications. Namely, IA number 11 is filed under order 18 rule 17 of CPC, seeking prayer to cross-examine the PW1 in further and one more, and to cross-examine the PW2 in IA number 12. Full stop. The said applications were resisted by the plaintiff. The trial court, after considering the material and record, by impugned order dated 24/2/2021, dismissed IA 11 and 12, and being agreed by the same, the defendants have presented this petition. I have heard Sri Prakash M.H. Lana counsel appearing for the petitioner, and Sri H. Pavan Chandra Shetty Lana counsel appearing for the respondent number 1 and 2. Sri Prakash Lana counsel appearing for the petitioner, draw the attention of the court to the various stages in the before a court, and further submitted that the defendants have filed the written statement at a belated stage, and further have cross-examined the PW1. However, for the reasons best known to the petitioners, they were not able to cross-examine the PW1 in full, and therefore sought for further cross-examination of the PW1 in IA number 11, and also sought for recall the PW2 to cross-examine fully. He further contended that in the event if such prayer is not granted, irreparable loss will be caused to the miscarriage of justice will be caused to the defendants. Accordingly, he sought for the interference of this court in the writ petition. Per contrast, Sri Pavan Chandra Shetty Lana counsel appearing for the petitioner drew the attention of the court to the finding recorded by the trial court, particularly the paragraph 7 of the impugned order, and submitted that though the opportunity has been given to the defendants to cross-examine. However, that they have not availed the same, and therefore, there is no due diligence on the part of the defendants to cross-examine the witnesses of the plaintiff. Accordingly, he sought for dismissal of the writ petition. In the light of the submission made by the learned counsel appealing for the parties, I have carefully considered I have carefully analyzed the impugned order passed by the trial court. It is not in dispute that the suit is filed for seeking relief of specific performance based on the sale agreement dated 23/3/2017. Full stop. It is also not disputed that the defendants have filed the written statement at the belated stage. Full stop. Taking into consideration the arguments advanced by the learned counsel appealing for the petitioner hearing, that in the event of the cross-examination of the further cross-examination of the PW1 and the cross-examination of the PW2 is not provided, an essential part of the cross-examination will be curtailed. In this regard, it is relevant to extract the law declared by the apex court in the case of so-and-so, reported in 2006, 1 SCC 75, wherein the apex court held that the procedural defects and irregularities which are curable should not be allowed to defeat the substantive rights or to cause justice. Full stop. Procedure never be made a tool to deny justice or perpetuate injustice by any oppressive or punitive use. Taking into consideration the law declared by the apex court, and I am of the view that a lost opportunity be made available to the defendants to further cross-examine the PW1 and to PW2 by next date of hearing before the trial court without fail. In the event if the defendants fail to avail the benefit granted by this court in the present writ petition, they cannot claim such benefit in future. According with this observation, the impugned order dated 24/2/21 passed by the trial court on IA number 11 and 12 are set aside, the defendants are directed to cross-examine the PW1 and PW2 by next date of hearing without fail. With this, accordingly, writ petition is allowed. You are there.
Please.
And Pavan Chandra Shetty is there. Engaging yourselves with a cost for the other side. Better. 2018 matter. No, sir. One file matter. 2018. Yes, sir.
49.
They are appointed. The partition suit, the therefore refused to accept the written statement filed.
Written statement. Suit for?
Partition.
Yes.
For both parties are rely upon the will. In fact,
which is the impugned order, sir? Which is the impugned order?
The impugned order is that
yes. Tell us. Yes.
That's all. But in the cash matter,
ಯಾವ ಫೈಲ್ ಮಾಡಿದ್ರಿ? Suit is of the year 2014. When the written statement was sought to be filed? After 7 years.
5 years.
Out of 5 years. That you will give cost. Nominal. This writ petition is filed by filed by the defendants in OS number 482 of 2014 on the file of the second additional senior civil judge and JMFC Devanalli, challenging the order dated 17/7/2021, rejecting the IA number 8 filed under section 151 of CPC by the defendant number 123. The relevant facts for the adjudication of this petition are that the plaintiff has filed a suit for partition and separate possession in respect of the suit scheduled property, and in the said suit, the defendants entered appearance and filed a written statement along with the application application under section 151 of CPC in IA number 8, seeking permission to file the written statement. The said application was registered by the plaintiff. The trial court, after considering the material record by impugned order dated 17/7/2021, rejected the IA number 8 and feeling aggrieved by the same, the defendants have presented this petition. Shri Murthy K. Lana counsel appearing for the petitioner contended that
Non-availability of documents.
Non-availability of
Documents and
5 years. For 5 years.
no, there are registered bill of 1970.
Submitted that the reason for delay in filing the written statement before the trial court for the bona fide reason that the defendants were not able to secure the relevant documents as set out in grounds number 1, 2, 3, and therefore the same has caused delay while filing the written statement before the trial court. He further submitted that in the event if the opportunity is given to the petitioners hearing to file the written statement, as the relief sought for in the writ petition is suit for partition separate possession in respect of the suit scheduled property, no hardship will be caused to the other side. Per contra, Mr. So-and-so and a counsel appearing for the respondent sought to justify the impugned order passed by the trial court and submitted that there is an inordinate delay of nearly 6 years in filing the written statement by the defendants, and therefore the impugned order passed by the trial court is just and proper. It does not call for any interference in this petition. Looking into the finding recorded by the trial court, as well as the relief sought for by the parties in the suit, seeking partition separate possession in respect of the suit scheduled property, and also taking into account taking into account the law declared by the apex court in the case of Salem Advocates Association so-and-so, reported in 2005 so-and-so. I am of the view that the apex court, I am of the view that the acceptance of the written statement is a procedural one in terms of the order 8 rule 1 of CPC, which is merely a directory in nature and not mandatory to accept the same within 30 days from the date of receive the summons. And in that way of the matter, considering the averments made in the petition as well as the affidavit accompanying the application in IA number 8, I am of the view that the impugned order dated so-and-so be set aside, impugned order dated 17/7/21 be set aside, IA number 8 and filed by the defendant under section 151 of CPC is accepted and direct the trial court to accept the written statement. However, I find force in the submission made by the Lana counsel appearing for the respondent that there is an inordinate delay of 6 years. In order to compensate the plaintiff hearing, the defendants / petitioners here are permitted to file the written statement before a trial court, subject to the payment of cost of ₹10,000 to be payable by the petitioners to the respondent / plaintiff, and accordingly the petition is disposed of.
Written statement is already
Accepted. Filed but accepted. Not accepted. Yes, sir.
Serial number 50, the Nagaraj.
No representation, list after vacation. List after summer vacation.
Serial number 51, T.S. Venugopala.
Yes, Venugopala? Yes.
Lord, I am appearing for appellant, petitioner in this matter, 51.
51, sir?
Yes, Venugopal.
Oh, yes, sir. Yes. No, no, senior counsel.
My Lord, it's
Now your instructing counsel is seeking time.
No, he is here, my Lord, he is here. Other side, it may be other side.
Very well. No, sir. Very same one. Someone, I think probably they have been informed. Very well. Other side is there, but someone is presented for the petitioner also. No, nothing else.
Anyway,
Just
yes.
No. Yes, sir.
My Lord, it's only refused in frame the issue with regard to the will and the gift deed.
Suit for, sir?
Suit for declaration filed by the plaintiff. The
Filed by-
plaintiff is the petitioner, my Lord, before this honorable court.
Yes, sir.
Your Lordship may kindly please to see the order dated 10/11/2021 for a moment.
Yes, page, sir.
Order dated, my Lord, order. It's an
Page-
order of this
page-
honorable court.
Order sheet. Order dated, sir?
Dated 10/11/2021.
Yes.
Sri Santosh, who appears on behalf of MS Vararajan, submits that wakalat would be filed for the consisting respond number 21 and 22 within 2 days. Sri so and so senior counsel is heard and grant of interim order.
Yes.
The question for consideration, my Lord, is whether the civil court is justified in rejecting the application and order 14 Rule 5, read with section 51 of the Code of Civil Procedure, refusing to frame the issue on due execution and attestation of the will dated 18/9/1951.
Yes.
Lord, we filed an application for framing the issue. That has
Yes.
been rejected by the trial court. Page 34 is the, my Lord, the impugned order.
Page 34. Yes.
34.
Yes, sir.
Kindly similar that there will
So already additional issue means already issues have been framed.
issues have, it is an additional issue with regard to the will and the, my Lord, subsequent gift deed.
Where are the issues, sir?
Earlier
Whether-
issue,
earlier issues framed.
Lord, just I will point.
Yes.
Page 89.
89. Yes. One. Yes, sir. Yes, sir.
My Lord, whether the plaintiff proves that he is the absolute owner and possession of the A scheduled property, whether the plaintiff further
Yes.
proves that the gift deed dated 18/9/2015 executed by the
Yes, sir.
20th defendant, my Lord, it is already there. Your Lordship may kind of please
Yes.
to see. Executed by the 20th defendant in favor of 21st defendant is not binding on him. Whether
Yes.
the defendant number 20 proves that the present suit filed by the plaintiff without the relief of possession is not tenable in view of the decree passed in OS number 8490. Whether the plaintiff is entitled for the relief sought for and what order and decree. Now, my Lord, they have claimed in the written statement, my Lord, that they have that the property is been willed in their favor in the year 1951. My Lord,
Yes.
therefore, we have filed objection and, my Lord, sought, my Lord, that the issue should be framed up with regard to the will. Kindly see
Where
the
are yes, sir. Proposed issues. Where is the proposed issues, sir?
yes.
Proposed issues by yourself. IA. Yes.
45.
45.
Page 40, my Lord.
Yes, sir.
Page 40.
Correct.
this the additional issue, whether the defendant 20, Sri B.S. Venugopal Reddy, proves that the grandfather, late also Muniswamappa, executed the will dated 18/9/1951 in respect of the suit deed property, and he had right, title, possession, and interest in the said property to execute the said will dated 18/9/1951. Whether the defendant 20, Sri B.S. Venugopal Reddy, proves that he had a right, title, possession, and interest in the suit Schedule D property to execute the gift deed dated 18/9/2015 in favor of his son, so and so. Now, my lord, this is the application file. Kindly see the order passed by the court, my lord, rejecting the application at page 34.
Yes.
Order on IA. Plaintiff filed this application under Order 14 Rule 5, read with Section 151 of CPC seeking framing of additional issues. Plaintiff in his affidavit annexed in support of the application stated that the defendant number 2 in his additional written statement filed on 17/3/2017 specifically pleaded that his grandfather executed the will dated 18/9/1951, and based on the said will, he acquired the right over the Schedule D property, and he, being the absolute owner of the said property, executed the gift deed, bequeathing the same to his son, defendant number 21. When such being the pleadings, an additional issue as stated requires to be framed. Therefore, the application requires to be allowed. Accordingly, the plaintiff prayed to allow the application. Per contra, defendant number 20 resisted the application and raised the objection, contending inter alia that the application is lacking for bona fides. Plaintiff filed the application to protract the matter. Plaintiff is not legal heir or testator of the will alleged. Hence, the plaintiff is not having any locus standi to dispute the said will. The matter under the said will is completely internal matter of late also Muniswamappa. Hence, the question of asking the validity of the said will by the plaintiff does not arise. Pausing for a moment here, my lord, the same property is the subject matter of the dispute. Defendant number 20 further contending that the plaintiff referring B schedule property as D schedule property, PW in his cross-examination admitted the plaintiff is not having any right or interest over the Schedule B property. Under the circumstances, plaintiff is nothing to do with the will dated. My lord, it is a D schedule property under the will. My lord, it's not a B. Defendant number 20 further contended that the gift deed is not proved. Then the property mentioned herein continues to be the property of himself. Hence, the question of his competence in proving the execution of the gift deed will not germane or relevant to decide the suit. Plaintiff is not concerned with the either B schedule property. Plaintiff has to prove the case in respect of B schedule property. Therefore, the decision in the above case does not in any way depend upon the validity of the gift deed in question. Plaintiff filed the application only to protract so and so. Peruse the application is the finding. Application, objection raised, peruse the pleading of both the parties and issues already framed, heard the counsel appearing for the parties. The point that which arose for my consideration is whether the additional issue as sought for requires to be settled, framed, what order. Then, my lord, if given the reason and rejected.
Yes, so what is the reason for
rejecting?
Yes, rejecting.
No, my lord, but they say that you have no right over the property. That is the subject matter of the suit, and that is the scheduled property. They claim that annexure D property is willed away in their favor in 1951, and thereafter, my lord, they have gifted the property. When the very same property is the subject matter of the suit, and they have claimed subsequently that under will, necessarily the issue should be there.
Yes,
they can't say that.
Whether you have taken any plea in the plaint with regard to the will dated 18/9/1951?
Yes, my lord, it is also there. Your lordship may kindly please to see the plaint. In 63.
63. Relating to the will.
Yes.
We dated 18/9/1951.
One minute, sir. 64, 65. Lord, the 64, middle of the page.
64.
Yes, about 10 lines from the top.
Yes, sir.
It is pertinent to mention here that survey number 8/5, this is the property in question.
Oh, you said according to it is a fabricated will.
Yeah. Yes, not belonging to Muniswamappa, son of so and so, bequeath the said alleged will dated. Defendant has fabricated the alleged will dated.
Yes.
So on. So it is, my lord, in issue. That should have been, my lord, without filing an application, the issue should have been framed.
Yes.
When a specific application is filed, that is, my
Yes,
lord,
sir.
wrongly rejected.
Yes, sir.
Otherwise, my lord,
Apparently, full other side is
Yes.
present with full senior advocate.
Yes. Yes. Yes,
therefore, my lord,
yes.
my humble submission is, my lord, this application should be allowed and the direct
Yes, very
court
well.
to frame the issue.
Yes.
The proceed with the case, my lord, within the time frame, my lord, your lordship can feel, my lord,
Yes.
adequate.
Yes, yes, sir. I think that they have raised a plea in the plaint. Yes.
Let me answer. Submission, property covered under the will and gift, and the suitable property are owned and received is not correct.
It's not correct.
Not correct. I will point out how. And kindly take the plaint.
Plaint.
Kindly come to paragraph 2.
Yes.
Paragraph 3.
Paragraph 3. The entire extent.
Next it is in page number 50. The date starts from page 47.
1 minute. Yes. Para 3, sir.
Para 3.
Ah.
The entire extent of agricultural land.
Yes.
Yes. South Tabo is 27 acres, 20 guintas, including Karab of 3 acres. The entire land is 27 acres, 20 guintas, including Karab 3 acres, was purchased from one Venkatappa by one Sri Indappa.
Yes.
2. Gandhara, son of Ramani, and 3. Muniswamappa, son of Alasuru Yallappa. This Muniswamappa is the grandfather of defendant number 20.
Muniswamappa is?
Alasuru Muniswamappa.
Ah.
He is one of the purchaser and that said the entire extent is 27 acres, 20 guintas.
Purchase is the grandfather of?
Defendant number 20. Who is respondent number 20 in the...
Yes, you are the contestant.
Velugopal.
Yes, correct.
Velugopal.
Yes.
And now we come to the next paragraph 4.
Yes.
However, he is one of the sons of late Buddha, one of the purchasers of land CGI in survey number 8 of Bukit and Bangalore, Bangalore South Plaza, by a sale dated 13 May 1927, mentioned by a world partition effected on 24/50. However, son of Bindappa acquired 2 acres of land situated in survey number so and so of Bukit village, as recited in the same dated 23/9/1997 by Srimati Nagarama, wife of etc. etc.
Yes.
Therefore, 2 acres is sold under the chain.
Yes, 2 acres of land.
Intermediate chain deeds is quoted.
Yes.
And finally come to paragraph 6.
Yes.
The same 2 acres of land, the same boundary mentioned in paragraph 4 above, was further sold by Nagam, son of late Kavya, to Srimati Gangam, daughter of so and so by the same date 21/1962, registered as document number so and so in the office of the sub-registrar of Bangalore so far. By the year 1980, he said Gangamma died leaving behind her husband so and so. Then 2 or 3 lines later, the same 2 acres of land situated in survey number 8 of Bukit Indrahara village. The boundaries of which are mentioned in paragraph 4 above was sold by the above said the legal representatives of late Gangamma to the late by the same dated 17/9/1980.
Yes.
Now 2 acres of land is purchased by the plaintiff under the CD dated 17/9/1980.
Yes, sir.
Kindly come to the late schedule. Before next schedule. Page 68.
Yes, sir.
68. Great ratio. Dry land within 2 acres, being a portion of land situated in survey number 8 of Bhupenagara, formally described as so and so.
Yes,
This
sir.
is the property that is purchased by the granting under that 1788 schedule.
Yes.
I mean the schedule. Survey number 8 is mentioned.
Yes.
This is mentioned in an update. By that time, it was already coded as 8 part 2. Kindly, now take the very same date at 1980. Page number 95.
95.
95. Kindly come to the schedule.
95 is a typed copy. Yes.
Type the copy.
No, 18/2.
That's one mistake. 8 part. Original schedule 18. Survey number 18 is not in the picture.
Picture.
It is survey number 8 only. Kindly come back to page number 95. And Karagade.
95, sir.
Karagade.
Yes.
Bhupenagara survey number 8 number. 8 number తీసుకుని మీరు అవుతుందండి. ఆ టైపింగ్ మిస్టేక్ 8 part, it is 8 part. Report to see to the original schedule, it is also marked as an next step. Kayal Bhatti. 8 part. Therefore, as plaintiff's land is survey number 8 part.
According to you, the plaintiff land is. According to you, the plaintiff land is 8/2.
8/2. Great schedule A part.
Yes.
Now, in relation to 8/4, kindly turn to next page. Great schedule B.
Only thing is how far it affects you in the event if the additional issues are.
Right. With respect to 8/3 and 8/5.
Will is with regard to
8/3.
Yes.
And 8/5.
These are all the subject matter.
8/5 later became 8/8. Now 8/3 is not in the schedule.
8/3 and 8/5
5 is later.
are with regard to the will, subject matter of the will.
Kindly turn to plain schedule D.
Plain schedule E.
D. For basic page 70.
70.
70.
Yes, sir.
All that is impossible. For land bearing portion of survey number 8, then 8/5, new number 8/8, whether it will extend of 19 meters. Therefore, D schedule with respect to which Venugopal Reddy responded 20 as executed division in favor of his son.
Yes.
Kiran Kumar, who is defendant number 21.
Yes.
He with respect to 8/5, which later on became 8/8. Plaintiff is not seeking any declaration with respect to B schedule property at all. Kindly come to the prayer portion in the page. What we accept at page
67.
67. Plaintiff is the acts.
2 acres of land situated in portion of the so and so.
Situated in a portion of survey number 8, though it says it is 8/2, the boundary standing is saving. Say here we mention only say 8 of Bhupenagara they go only Bangalore Sultan described in schedule A here 2 and that the 28th defendant has not acquired any right to pay to an interest in schedule C property.
Yes.
Look at the schedule C property. It is 8/4.
Yes, sir.
B schedule property is also 8/4. Plaintiff himself states in the claim, B schedule property is purchased by my grandfather Muniswamaka in a sale dated 30th March 1930.
Yes, sir.
The court gets it in the plate itself. 1 acre is 8/4.
Yes.
His land is 8/2. He seeks for a declaration with respect to A schedule property. Then a negative declaration that defendant might be have not acquired any right to.
Yes, sir.
He may be respect to survey number 8/3 and 8/5.
Yes. Yes.
The real report finds at page 276.
276.
276.
Yes.
Gift deed.
264.
There is a gift deed.
Gift deed.
270 is gift deed. 264 is deed.
Just a minute. Gift deed dated 18th September
2015.
2015. Yes.
The issue is framed with respect to the issue number 2.
Ah.
But that was unnecessary because that gift deed with respect to 8/5 not the subject matter of the issue. It was, in fact, it was for me to file an application to delete that issue. So I have not done that. But anyway, his prayer in the present application is frame the issue regarding the gift. And
Yes.
frame an issue regarding the gift.
Yes.
Gift deed issue number 2 is therefore it was
Yes.
unnecessary as I said. Now kindly take this bill. ಸರ್ ಒಂದು ಸಾವಿರದ ಒಂಬೈನೂರ ಐವತ್ತೊಂದನೇ ಇಸ್ವಿ 18/9/2011 ಬೆಂಗಳೂರು ತಾಲೂಕು ಬೇಲೂರು ಹೋಬಳಿ ಬೊಮ್ಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಜಿರಾಯಿತು ಕಸದಿಂದ ಕಾಣುತ್ತಿರುವ ಹಲಸೂರು ಯಲ್ಲಪ್ಪನವರ ಮಗ ಸುಮಾರು 75 ವರ್ಷ ಪುಂಚಾಮಕ್ಕನವರ ನಾನು ಅದರಲ್ಲಿ ನಾನು ವಯಸ್ಸಾಗಿದೆ ಯಾವಾಗ
Yes.
ಅಂತ ರಿಸೈಟಲ್ಸ್ ಇದೆ ಕೈಲಿ ಸ್ಕಿಪ್ ದ ಪೇಜ್ ಕೈಲಿ ತಲುಪು ದಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್
ಶೆಡ್ಯೂಲ್ ಈಸ್ ಓಲ್ಡ್ ಸರ್ವೆ ನಂಬರ್ 8 ಅಂತ ಹೇಳ್ತಾರೆ.
Yes.
ಇದೆ ಎರಡನೇ ಪೇಜ್ ಆನಂತರದಲ್ಲಿಯವರು ಸ್ವಂತ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದು 1938ರಲ್ಲಿ ಕೋಡಿ ತುಳಸಿ ಮೇರೆ ನನಗೆ ಬೆಂಗಳೂರು ತಾಲೂಕು ಬೇಗೂರು ಹೋಗಿ ರೂಪೇನಗರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 8/5 ಸಂಬಂಧದಲ್ಲಿ 3 ಎಕರೆ ಜಮೀನಿನಲ್ಲಿ 2 ಎಕರೆ 20 ಗುಂಟೆ ಕೃಷಿ ಜಮೀನು ಅಂಕಣ ವಿದ್ಯಾರ್ಥಿಗಳ ಸುತ್ತೋಟಿನಲ್ಲಿದ್ದು ಉಳಿಗೆ 20 ಗುಂಟೆ ಜಮೀನು ಕೃಷಿ ಜಮೀನು ಮತ್ತು ಇದೇ ಬೆಂಗಳೂರು ತಾಲೂಕು ಬೇಗೂರು ಹೋಗಿ ರೂಪೇನಗರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 8/3ರಲ್ಲಿ 4 ಎಕರೆ 33 ಗುಂಟೆ ಕೃಷಿ ಜಮೀನು.
Yes.
As I said, Musamapa is one of the purchaser of the 27 acres 20 guntha.
Yes.
He has his share in it. Number 2, he purchased 1 acre which is the B schedule property under the same deed. Therefore, he has vast land. Now, in the deed is with respect to 8/5.
Yes.
That is the subschedule D property.
Yes.
And another extent of 4 acres 33 guntha in 8/3, which is not the subject matter of the subschedule property. Okay, we go to the schedule in the QC.
Schedule in the
Schedule in the QC.
will.
In the
Page.
ಅದರಲ್ಲೇ
Page.
267 ಬೆಂಗಳೂರು
267. 267 ಅಲ್ಲ?
267
267. Yes.
ಬೆಂಗಳೂರು ತಾಲೂಕು ಬೇಗೂರು ಹೋಬಳಿ ವಿದ್ಯಾನಗರ ಗ್ರಾಮದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 8/3 8/3ರಲ್ಲಿ 4 ಎಕರೆ 33 ಗುಂಟೆ
Yes.
ಹೋಬಳಿಸಲ ಬಿಟ್ಟು ಬಂದ್ರೆ ಈ ಮಧ್ಯೆ ಇರುವ 4 ಎಕರೆ 33 ಗುಂಟೆ ಜಮೀನನ್ನು ನಾರಾಯಣ ರೆಡ್ಡಿ ಮತ್ತು ಮುನಿಯಪ್ಪ ರೆಡ್ಡಿ ಅವರಿಗೆ ಸೇರತಕ್ಕದ್ದು. ಅದನ್ನು ಮುನ್ಸಾಮಪ್ಪ.
Yes.
Then next, ಬೇಗೂರು ಹೋಗಿ ರೂಪೇನಗರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 8/5 5ರ ಪೈಕಿ 20 ಗುಂಟೆ ಜಮೀನು ಕೃಷಿ ಜಮೀನಿಗೆ ಆಕಾರವುಳ್ಳ ಜಮೀನು ಸುತ್ತಿಗೆ ಚಟುಬಂದಿ ಆ ಚಟುಬಂದಿಯಲ್ಲ ಆದರೆ ಈ ಮಧ್ಯೆ ಇರುವ 20 ಗುಂಟೆ ಕೃಷಿ ಜಮೀನು ಶಾಮಣ್ಣ ರೆಡ್ಡಿ ಅವರಿಗೆ ಸೇರತಕ್ಕದ್ದು. ಶಾಮಣ್ಣ ರೆಡ್ಡಿ is son of Halasu Munswamappa. He is the father of Venugopal Reddy, respondent number 20. Therefore, in the year 1951 itself, what is filled by Munswamappa in favor of his sons is 8/3 and 8/5.
Yes.
Now, 8/3 and 8/5 are not the subject matter of the suit.
So not the subject matter of the suit.
8/2 and 8/4 are the subject matter of the suit.
Just a minute. 8/2.
8/4 is
8/2 and 8/4
4.
are the subject
As far
matter.
as 8/4 is concerned,
Are the subject matter of the suit.
are the subject matter. In fact, he is not asking any declaration with respect to 8/4. He has mentioned that to show that my property is 8/4. 8/4 is a portion of
Well.
survey number 8, which is purchased by Munswamappa under a city.
Yes.
One acre. The remaining is he gets as of right because he is the giant father of right.
Yes.
Now, really, next, there was an earlier suit between us with respect to 8/4 where I was the plaintiff.
My lord,
Yes.
I may be permitted to intervene at this stage. My lord, the whole case is, my lord, there is a change in the survey number 8/2 and 8/4. They have
Yes.
manipulated, they have sold entire property fallen to their share. There is absolutely no property. They have manipulated survey numbers and executed the, at least they have been a will.
Yes, sir.
This is the whole subject matter is the change of survey number.
Yes, sir.
Page 180.
180.
180.
Yes, sir.
The judgment in the earlier
Suit.
where I was the plaintiff.
You are the
That suit
plaintiff.
was filed by me with respect to what is present plain pre-scheduled property. 1 acre of land in survey number 8/4.
Subject. This is a suit for permanent injunction.
Permanent. 20, turn to page 191.
191.
191.
Yes, sir.
20 comes down below, paragraph 70.
Yes. DW1.
DW1 has no doubt given evidence reiterating his defense. But the fact that it centers around the land in survey number 8/2 cannot be lost sight of. 8/2 is the present pre-scheduled property, though he mentions it as survey number 8. He said it says it is 8/2. 8/2 cannot be lost sight of. Added to it, when he himself has categorically stated that his property has nothing to do with the scheduled property. Scheduled property in that suit is 8/4. It is the present plain pre-scheduled property.
Yes, sir.
Nothing to do with the property. So I see.
Yes.
Next. Claim and challenge the testimony of PW1 as to be seen from exhibit D3. D3 is recently dated 17/9/1980.
Yes, sir.
Exhibit D3, he had purchased 2 acres of land in survey number 8/2 of Upinagaraha, but the boundaries of it and that of the scheduled property are different as they do not
Overlap on each other.
not visited so and so. Therefore, this case is with respect to 8/2. This case is with respect to a scheduled property.
Yes.
The foundation for the suit is that 17/9/1980 sharing.
Yes, sir.
It has nothing to do with the other sub numbers. This is number 1. Number 2, let's assuming for the sake of argument that the issue is framed on the will and the miserably failed to prove the will. What is the position? It becomes munsama of property. We are legal representatives, lineal descendant of munsama. Even in the absence of
the property will come to you.
Therefore, minutes, as far as the plaintiff is a total stranger to the defendant's family, he cannot raise the issue of the will. If I fail to prove the will, all that results is 8/3 and 8/5.
It will go to the legal representatives.
Go to legal representative Samaka.
Yes.
Again, I come in the claim because there is no dispute. The Munsamaka's son was Shaman and then Vienna responded for 20 years.
Yes, sir.
Son of, so there is no dispute.
Yes.
Therefore, when his suit is with respect to 8/2,
Yes.
that he may not be concerned with any other document which does not deal with 8/2.
Yes.
If the document had dealt with 8/2, you can understand. That is not the case.
Yes.
Therefore, minutes case.
Yes, sir.
The application is rightly discussed.
Yes, sir. Anything else? Male, sir.
The only point is, now, my lord, they have no objection for raising the issue, my lord, with regard to the gift. And my lord, the gift follows from the will.
Yes.
Unless they prove the will, the question of gifting the same property
Does not arise.
Does not arise. Therefore, naturally, my lord, one has to prove the validity of the will. Then only, my lord, the flowing of title will pass on to the other persons.
Ultimately, the gift will be considered.
That's right, my lord. There is no harm, my lord, caused to them. Only
Yes.
thing is they have to prove there is
Yes.
a validly executed will.
Yes, sir.
They can't shame away.
I will
saying
consider
that
it.
it should not be.
I will consider it. Sorry, sir. Yes. Heard and resumed. Remaining matters will be taken. Date.
The interim order has to be extended.
Just a minute. How many matters are there? Just to call it.
Serial number.
ಅಲ್ಲ ಮತ್ತೆ ಅವತ್ತು ಏನಾದ್ರು ಬೇಕು.
Serial number 52.
Just
CHT Rudresh.
52. After vacation. Just after vacation, at the request made by the Lena Council for the petition. Yes, sir.
53 adjourned. 54
Shiv Prakash. After vacations. Huh? After vacation.
And the day itself, I made an application to secure the copy. Till date, they are not issued a copy to me. Only after securing the document, I can.
No, after vacation it will be taken.
We have received copy and it is also on record. The matter involved very urgent for me in that manner. They responded to the.
Then next week let us. Only thing is it has to reach. That's all.
Now the commissioner report at their instance, survey is
Yes,
appointed and
third.
almost all 8 months are
At the
over.
request made by
And I
the-
am telling them
At the request made by the Rana Council, at the request.
Now the report is in our favor.
Yes, yes. Due to paucity of time, the matters not reach list. We have it next week. Next week better. No, next week. Next week already we have only 3 days.
No, my lord, the commissioner report.
19. 19. Sir, next week, no, Monday it will not reach. Monday, even preliminary will not reach. Don't worry about B group. Yes, sir. Don't worry about the B group. No, that cannot. Next matter, 55. Interim order, just a minute. 54 ಅಲ್ಲಿ one ನಿಮಿಷ B group ಅಲ್ಲಿ interim order granted earlier, next date of hearing. Yes, cabinet. Yes. Yes, after vacation. Yes, after just after summer vacation, 55. Interim order is there.
Yes.
Interim order granted earlier, extended till next date of hearing. 56. Just after vacation.
Because already they themselves had submitted before the trial court and not requested for judgment.
No.
Now, at the stage of judgment, they find the petition and
Just a minute. This matter.
And after Monday.
19th. 19th. Interim order is there. Interim order is there. Interim order granted earlier, extended till next date of hearing. Monday only, say 18th. Monday, 18th. Correct, Allah. Not that Monday is asking. I'm saying it's a Monday. He asked for Monday, given Monday. Yes, yes. Chidambar? So 18, 19th any day. 18, 19, any day of your choice. Not Monday. Monday, even I told you, preliminary may not reach. Reason is not for you, reason for me. It may not reach. List on 18, 19th any day.
Dismissal of suit for non-prosecution.
Okay.
Another suit filed by the brother.
See, 18, 19th any day. 18, 19th any day you can take. Yes, 18. Yes. 58.
I appear for the respondent, my lord. Kindly have it on 18th or 19th, anytime.
Any day. Interim order granted earlier, extended till next day.
18th.
Yes, sir. Just a minute. Yes, sir.
58, 18th, my lord.
50? Any case? ಅದು 18th, 19th. I don't know. It will be taken up. It will be taken up. All matters it has to be considered. Every day.
Sorry, my lord. My lord, serial number 58, 18th.
50?
58.
58. 58. 19th. Very good.
Mobilize.